Looks like if they know that she's.
All right, good morning, everyone. We are reconvening the Burgess and Rogers appeal on today, the 10th of June, 2021. The appearances of the parties are as stated before, and the proceedings are again before my Lord President, Sir Christopher Clark, and Justices of Appeal, Morris Kay and Jeffrey Bell. Ms. Mulligan, I think we pick it up with you.
Have we got everybody? Yes.
Could the corrections facilities activate their cameras, please? Thank you, Co-Ed Westgate. Is there anyone there for Westgate? Okay, Westgate is going to somebody's gate.
Whilst we're waiting, we've seen Mr. Richardson's proposed added ground. Has everybody else seen it?
Mr. Mahoney has, because he responded to it.
Yes, I received a copy a few minutes ago.
Oh, right.
Well, I see that Westgate is on the call, but their camera is not activated, and someone's just muted the mic. There we go. Mr. Rogers, can you see and hear us? Okay, I see you moving your mouth, so I assume you're saying yes. Okay. All right.
Right. I'm sorry, I haven't seen Mr. Mahoney's comment on it. Hope somebody could send it to me.
Justice Bell, were you referring to the email that I
Yes,
sent?
I was.
You're looking for an email about 15 minutes ago, Sir Christopher. Had an authority in it.
Oh, yeah, well, I've got an email which has
And if you scroll down, Mr. Mahoney made a reference to it.
oh, I see. Oh, I follow. Yes, I see. I'm so sorry. I simply clicked on the case without the comment before. Right. Okay. Ms. Mulligan, you're.
Yes, good morning.
Good morning.
So essentially, I think I mostly just need to tie up loose ends with respect to the lost evidence ground and abuse of process. To be clear, just to enumerate what is in the written submissions, there was the search warrants, the information sworn for the search warrants, search reports, and the statement of Mr. Rogers, apparently given that day, that were all missing from March 13th, 2008. That was the day that the police claimed that they seized the work boots and the sneakers belonging to Miss Card. I say that the footwear that was seized from that apartment
Can we just pause there a moment? I mean, what's the significance of the search warrant? For present purposes, it says we want to search a house.
Yes, and my information, but I couldn't, well, it's difficult for me to say. I would have liked to have challenged whether there was in fact a search warrant, but I had two officers on the stand who were saying there was a search warrant and there was a search conducted on that date and time. But I had no, well, all I had by way of evidence of that was their evidence and that the search warrants were lost. all of the other search warrants and informations were retained, but this one day, not only the search warrants, the informations, the search reports, but also my client's statement were all lost.
Sorry, your client's statement, do you mean what he said to the police at the time? Or?
Yes, his witness statement.
Sorry, when did he give a witness statement?
March 13th, 2008,
Right, okay.
but it wasn't available either. So all of those items were lost after the fact. After the trial began, we raised the issue. Then we received statements saying, well, perhaps they were in a box that got flooded, or perhaps they were somewhere else. Perhaps they got lost in the reviews that took place. Nobody really knew what happened to all of that.
Did you suggest the officers that there wasn't a search warrant, and they said yes, there is?
Yes.
Right.
Yes, they maintained that there was, even though we had no evidence, no hard evidence of it other than what they were saying.
But
Is there any dispute but that
Yeah.
what was taken were your client's boots?
Yes, there was it was impossible to raise the issue effectively. Miss Card says she was not home at the time. The police say she was. The officers who testified said she was there. She says she wasn't. And there was an issue as to whether, in fact, the boots were seized at that time, at that place. But I couldn't, it was impossible to address. All we had was the evidence of the officers that said, yes, we did, even though we have nothing to show for it. We have none of the paperwork.
I'm sorry, that's not quite an answer to my question.
I'm sorry.
Is there any issue but that what was seized were your client's boots?
It's difficult to answer that, and I'm sorry, I don't mean to be difficult, but I would have liked to have challenged whether or not they were his boots.
And where would that take you? Where would that go, Miss Mulligan?
Well, to the extent that Jan Johnson compared them and said that they could have been the boots that left the impressions at the scene.
And
Well, this is all slightly unreal. We know that, just a moment, let me finish before you answer the question I haven't yet asked. We know that the police got hold of some boots, and we know that they were tested to see whether they were identical or similar to the prints that were made at the scene.
Mm-hmm.
There are really only two possibilities. One is that they seized your client's boots, either pursuant to a search warrant or not pursuant to a search warrant, or that they took a completely different set of boots which had nothing to do with your client, but as it happened were of the similar make to that of your client, and wholly dishonestly put them forward as your client's boots when they were not. That's the only two logical possibilities.
Yes, it is.
Well, was it seriously suggested that that's what the police had done?
I wasn't in a position to seriously suggest anything, given that the evidence that I had to deal with was two experienced officers who said, we seized these boots from this home with Miss Card present, although that was contested by Miss Card. And we had a search warrant and we had an information, and they've simply gone missing. I don't know how much, without calling my client, how much I could seriously contest that.
No, well, there you are.
But the problem being that, our position was that there was no search warrant, that there was no information, that there was no search report for good reason. But
what good reason?
We also have Ms. Card's evidence.
What good reason?
In that they did not, in fact, seize the boots from that location on that date.
But they seized somebody else's boots.
Well, that's unknowable to me. I don't know whose boots. But Ms. Card identified them in her way as being Mr. Rogers' boots. So there was also that evidence.
Right. Did you suggest to her that her identification was mistaken?
I cannot recall if by that point we did or did not.
Because if you didn't, it doesn't matter whether there was a warrant or not. If the position was that she said that they were his boots, and you didn't suggest to her that she was wrong in identifying them as his boots, then the evidence before the jury were that they were his boots. And for present purposes, it wouldn't matter a hoot whether there was a warrant or the day upon which they were seized. You may infer from the tone of my voice that I don't think this is one of your better points.
Yes, I do infer that. Thank you. The other issue with the footwear, moving on,
Yes.
is that the boots and shoes that were seized by the police from persons who first attended the scene presumably were seized by the police, and casts were made of the soles of the shoes and photographs were taken in order to provide them to the expert for comparison and elimination purposes. That never happened. And the boots, save and except for Mr. Angelo's, and shoes were all returned to their owners or went missing. The footwear impressions taken, the casts taken from that footwear all went missing. And the photographs taken of that footwear all went missing.
Yes.
So there was no way, one, for the prosecution's expert to have looked at them to see if perhaps one of them had a similar sole, somewhere between size 7 and 11. And there was no way, certainly for the defense, to say to the jury, well, look, this one's the same or similar. We never had the opportunity. Further, Miss Johnson had not preserved her notes from the scene made contemporaneously with her examination of the scene, or her notes related to the examination of the footwear. So we could not examine her in any meaningful way about the steps she took and what she did. In fact, she gave general evidence about what she would normally do and her usual procedure, but she didn't have notes of what she had, in fact, did in this case. And I set out at page 5 of my submission some of the sort of ridiculous results of that. In my examination of her, she came to trial and had looked at the photographs and made some new notes based on looking at the photographs some 13 years later. And so I set out just that portion where she's looking at something that doesn't refer to the question I asked her. So I noticed that you are both, when you're asked about Area 20 and now again referring to some kind of note or something in your binder. Is that a note that you made? I just made it to reflect the date. I took it from my CDs, which was in my file. I just made it for quick reference, but the dates are on my CDs, when the CDs were taken. But when you were asked about Area 20 a few minutes ago by my friend, you said that was cast off and you referred to something in front of you. Is that some notes you made? My report, you have my report, yes. Does that refer specifically to Area 20? No, it does not. So that would not have assisted you, no. So did you go back over, let me put it this way. Normally you would document with notes the entire scene, what you did there, what you saw, your early observations, what processes you used. Normally you would document that all in notes, correct? Right? In this case, is it fair to say you would have done that? I did do that. However, we don't have any of those notes, correct? That's correct. And then she explains why. So she's referring to a report to answer a question about Area 20 that doesn't refer to Area 20. It was a most unsatisfactory position, both probably for the expert, but also for us, because we couldn't trace her steps. We couldn't examine how she came to her conclusions, what work she did to get there. I've set out some of the issues with her evidence there. I note also in this regard that Dr. Obafunwa's notes as to what he did and observed during the autopsy were also missing and not provided to the defense. So again, the basis upon which he came to his conclusions and wrote his report was not available to be cross-examined on. I think I've covered, there were actually a couple instances where the police failed to make notes of conversations with the only two witnesses against Mr. Rogers. And that's over on page 10 of my submissions. There was, first, there was the Crime Stoppers meeting, which took us some great time to get the notes from that, and then they were heavily edited, but we did eventually get them. There was the April 2015 meeting with Ms. Card, DC Donovan, Inspector Redford, and Sergeant Matherin. Sergeant Matherin took the notes during the 1 hour and 5 minute meeting, and the only note he made was that the purpose was to ascertain how Ms. Card could be of use to the investigation. And then on August 9th was the meeting where both Ms. Foley and Ms. Card were present, and the only note was the murder of Marcus Gibbings, followed by the correcting statement of Ms. Foley about dates. So we submitted in all the circumstances that, coupled with the ongoing disclosure, the court will notice that there were at least 16 notices of additional evidence. And some of that's referred to by the trial judge, but we say in the circumstances that either the trial judge ought to have stayed the proceedings because Mr. Rogers could not make full answer in defense, or as disclosure kept being provided, ought to have mistried the proceedings. But at the very least, in my submission, the issue should have been dealt with square on with the jury, and I submit they were not. And I say that not because the judge did refer many times to delay and missing evidence, but in my submission, he did not assist the jury with what to do with that. It was the trial judge's job on the abuse application to determine whether the prejudice was such that Mr. Rogers could not have a fair trial. It was the jury's job to determine whether, as a result of the missing evidence and the inability, if they so found it, for the defense to challenge the prosecution evidence, whether they were going to place any weight on that particular piece of prosecution evidence. But he didn't tell them that. And I can take you to that. What he told them was more, you can consider it, you can look at it, you can consider whether there's prejudice. But what they needed to be told in my respectful submission was that if they found the defense as a result of the failure of the police or the prosecution to preserve or disclose evidence, was unable to effectively challenge a piece of evidence for that reason, then they would be entitled not to place any weight on the prosecution evidence on the point, if they chose. But they weren't told how to and I would begin at page 56 of the summation, and it will be my submission at the end of the day, that it was a very vague, almost an instruction for them to consider what prejudice there was, but not telling them what they could do with it. At page 56 of the summation, at line 20, the court tells the jury, you should also make allowances for the fact that from the defendant's point of view, the longer the time since the alleged incident, the more difficult it may be for them to address and defend themselves. Of course, it makes it more difficult for the prosecution also, but ultimately, as we have seen in this case, that has, by way of another example, had the effect of preventing, again, in the case of Mr. Rogers, a comparison of footwear impressions from the shoes and boots of people who we do know entered the crime scene to ascertain whether their footwear could have made the impressions left at the scene also. That is something the defense would clearly have liked to have been able to do in this case, but have been prevented from doing so as a result of the delay in these proceedings. Shoes and boots that were seized have been lost or returned to their owners, and save for Angelo James' boots, seized by Detective Don De Silva, the photos and or prints of their outsoles have been lost. The fact of their loss may or may not be surprising given the passage of time, but the effect on the defendant's ability to mount a full defense is something you should consider, whilst of course maintaining a sense of perspective. Now, I'm certainly not suggesting, because you know, based upon my direction to you, that that would be wrong, that you should speculate as to what other evidence there may have been. You simply can't do that. I'm just directing you that as you separately consider the case against each defendant in turn, and the evidence solely admissible against each of them, you bear in mind the potential prejudice that may have been caused in the delay in bringing them to trial by reason of, for example, missing police exhibits or missing documents. You might think the loss of the warrants from March 13th, 2008 search of Mr. Rogers and Mr. Card's 9 Crossland Lane apartment is another example. There's accepted evidence that some 43 other warrants, which can still be located and have been served on the defense, that were obtained and executed in respect of this investigation. And whilst the defense suggests to you there's something suspicious perhaps about these 2 specific warrants having gone missing, remember that you have also heard the evidence that a whole box of documents, I think Detective Constable Redfern said, starting from document 250 to 300, is missing in respect of this case, which are thought could include these warrants. I think the prosecution may also be entitled to ask you to consider why, having obtained 43 other warrants, would the police, and particularly Detective Constable Augustine, as he then was, when we know that he obtained and served other warrants in this case, not simply have obtained warrants for these 2 searches, just as he told you that in evidence that he did. Ultimately, as with every other question of fact in this case, it is for you to decide what evidence you accept and what you reject, and whether you consider the complaint significant or ultimately of minor effect. Consider, however, the effect of the delay and resultant loss of documents and police exhibits may have had in prejudicing these defendants in presenting their respective cases before you. I'll just read a little bit more and then I'll turn to my point. Also in the case against Miss Burgess, because this dovetails into Mr. Richardson's submissions, we are unable now to confirm over and above what Miss Burgess told the police herself back on October 26, 2006, what if any message was left during that 9:07 telephone call from Miss Burgess's work phone to Mr. Gibbings' cell phone on the night of the 25th of October, 2006. After 14 years, Chief Inspector Cardwell is unable to say what, if any, information was received in response to the 2 warrants the police served on M3 Wireless. Does that, as Mr. Richardson submits, really impact on the issues you have to consider in this case? Or is it the case, as Ms. Mahoney submits, that what is more important is the earlier call when it was said that their meeting was arranged? And then he goes on to talk about the further disclosure over and above all that you have heard, that even during the course of this trial, even nearly 14 years after the death of Marcus Gibbings, the defendant's counsel are still receiving disclosure from the prosecuting authorities, including the emails that are now in evidence. And whilst that may be something that in a trial closer to the time of the offense could relatively easily be dealt with, you might consider that it would be considerably more difficult after almost 14 years. The difficulty with all of that is, yes, it points out the problems, but it only tells the jury that they can consider, think about the prejudice to the defendants, but it doesn't tell them what to do with it. If they find that there was, in fact, prejudice, if they find that the defense was unable to challenge effectively a piece of prosecution evidence because of the lost evidence.
Well, you have to read the next paragraph as well.
Yes, exactly.
Okay. Does that, sorry, over and above all that. So ladies and gentlemen, even if you believe the delay in this case is understandable based upon concerns, for example, that Miss Card told the police she had for her safety, which resulted in her not being willing to give a statement to the police until the summer of 2018. Even if you were to accept that, if you decide because of the delay, reasonable or otherwise, the defendants have been placed at a real disadvantage in putting forward their case, take that into account in their favor when deciding upon the whole of the evidence, in this case, admissible against the defendant, whose case you are considering, whether the prosecution has made you sure of their guilt. In my submission, that doesn't advance the jury very much. Take that into account. What they needed to be told was if they found the defense could not effectively challenge a particular piece of evidence as a result of the failure of the police to preserve it or the prosecution to disclose it, then they could, if they chose, place no reliance on the prosecution evidence on that point. They were never told that.
Presumably that's what you or Mr. Daniels had submitted to the jury.
Well, but it has to come from the judge. The law directions come from the judge. The directions on how to deal with the law. We tell the jury, if we get it wrong and the judge says something different, don't listen to us. Well, it's for the judge to tell the jury how to apply the law. And in my respectful submission, he essentially turned over the job of considering whether there was prejudice to the jury, but didn't tell them what to do if they so found it. He said, you can take it into account. You can weigh it in their favor.
Well, how otherwise could they take it into account, otherwise than concluding, if they were minded so to do, that because of the absence of documentation that once existed but no longer does, we can't be satisfied or in any event sure that that which the police officer has told us is accurate.
Yes, but he didn't say that. I agree.
Well, I know he didn't say that, but he said what he did say.
Yes.
And for my part, I find it difficult to think what the jury could have interpreted that as meaning, other than that which I have just said.
Well, I don't know what the jury interpreted that as meaning. It looks to me like they should have some sympathy for the defendants in the circumstances. They should consider whether it be difficult for them. But it doesn't go so
Well, it doesn't say that. It doesn't say you can have some sympathy.
No.
It says you must take that into account in their favor when deciding whether the prosecution has made you sure of his guilt.
Yes, but not in particular in relation to the evidence that they couldn't challenge. Not to say to the jury, you would be entitled to reject the evidence of the prosecution on this point if you find the defense was so prejudiced that they could not challenge it. That doesn't arise in his directions. And in my
Is it right that at the conclusion of the summing up, the judge asked whether counsel had any comments to make, and everybody said no?
I believe so, yes. Yes. But regardless, sometimes with the benefit of some time to look over things, you do see things that you didn't notice in the moment. And this seems to me to be quite important in that the jury needed to know. It's same with Mr. Richardson's point. Had the jury been told, not does it really impact on the issues whether or not she left that call, had they been told that they had to consider that she had in fact left that voice message, the weight of it was for them, but they had to accept that she left it in the circumstances. Not only would it have impacted potentially Mr. Richardson's client's case, but what impact would that have if they accepted that Miss Burgess had left that voice message? The court has to consider what impact that would have had on the credibility of Miss Card and Miss Foley, suggesting that Miss Burgess had set up this thing or had paid for it to happen. So it was a joint trial, and all of these issues affect both. And so in my respectful submission, that instruction to the jury was not clear enough. I take what your lordship is saying, that maybe the jury would have decided they could reject the evidence, for instance, of Jan Johnson, if they found that the defense was not able to properly challenge it as a result of the lost shoes. But maybe they would have just said, well, yeah, it was difficult for them, but they did a pretty good job, so let's move on. I don't know. And
they were entitled to do either of those.
But they weren't told they were entitled to do they weren't specifically told they were entitled to place no weight on the evidence that we were if they found we were unable to challenge it.
Difficult to know why it would be proper to place no weight on it.
Well,
If that was the general proposition, every time there was a missing document recording what had happened, you wouldn't be able to accept any evidence that it did happen.
well, I suppose they could have said that you're entitled to place such weight as you think it, such weight as you may ascribe to it if you find that the defense was unable to challenge it. I suppose it doesn't have to be no weight at all, but they should have been told they can do something with that piece of prosecution evidence that the defense couldn't challenge. Not just that they could take it into account or consider it or consider the prejudice.
Okay.
With respect to I think that closes that point off. I've covered much of the other evidence already. With respect to the jury pressure issue, I adopt and rely upon Mr. Richardson's submissions. I did in my written submissions. I do so here again. I don't think there's anything that I can usefully add to what he has said to the court.
Right.
That takes us to the unreasonable verdict. And I recognize that the court may think this is sort of the throwaway ground in most appeals, but it really is not in this case. In respect to Mr. Rogers.
Isn't it coextensive with the submission of no case?
To some extent, yes. To some extent, yes. But even if the court were to find there was some marginal case to leave to the jury, it still doesn't necessarily mean that the verdict at the end of the day, having heard all of the evidence, was reasonable. And I'll sum it up very quickly. I mean, at the end of the day, the jury was left with, as the trial judge told them, they had to be satisfied on Card and Foley's evidence. That the other evidence, Dr. Obafunwa and Jan Johnson, was really meant to be somehow supportive, but it would not stand alone. So just in summary, Ms. Card's evidence that he confessed, but then the rest of it, I say it would be unreasonable. He hid behind the couch was unlikely. He got him from behind was wrong. He buried his clothes, including the sneakers he didn't wear at the scene, according to the prosecution, but retained the boots that he did wear at the scene, according to the prosecution. Subsequent DNA testing of the boots on a spot that appeared to be blood turned out not to have anything to do with the scene. No evidence whatsoever to support the suggestion that he was paid or said he was being paid or any of that. Ms. Foley ended up, her evidence was he said he did it because her evidence that he hid behind the couch, as you heard yesterday, was not not what she told the police from Mr. Rogers, but allegedly from Mr. Card. So that's the bare evidence she gave. He said he did it. And that's the evidence that the court quite properly instructed the jury that they would have to rely upon in order to convict. And in my submission, given the problems with that evidence, coupled with the clear hatred by both, their common enemy being Mr. Rogers, that it would be unreliable, unreasonable for the jury to convict on the basis of solely that. My friend, Mr. Mahoney, has put into his submissions that there would be, even if the court found errors, there would be no miscarriage because the case presented by the Crown was overwhelming. And I submit clearly, I don't agree. And the directions were correct, and clearly I don't agree. But again, I asked the court to consider that this was indeed a joint trial, and to consider, when you're considering the matter, that any errors made in relation to Ms. Burgess, what effect that also may have had on the case for Mr. Rogers.
Sorry, would you say you were inviting us to consider whether any errors made in relation to Miss Burgess affected Mr. Rogers?
Yes,
Not that every error in relation to Miss Burgess must have affected Mr. Rogers.
no, whether any error may have affected, such as as the example I gave, that if the jury had been told, if the court finds the jury ought to have been told, that they should accept as uncontradicted Miss Burgess's statement about what was in the voice message. The weight, of course, is for the jury to decide what weight they would put on it. But if they were told that they should accept as uncontradicted what she had to say about what was in that voicemail, it would tend to suggest that Miss Card certainly was not telling the truth, or the jury might come to that conclusion. If they did accept that Miss Burgess had said that, and if they did find it to be a sincere statement, then it meant this whole thing about Miss Burgess setting it up and paying Mr. Rogers for the murder may have been less likely in their minds. Similarly, you know, Mr. Richardson pointed out that the cases were not kept separate. Well, that's true, and it's also true if it had been, what effect would that potentially have had on Mr. Rogers' case? Miss Burgess, there was a lot of evidence we didn't ask any questions about. All of the evidence that tended to perhaps raise some animosity towards Miss Burgess, all of the beast evidence and the arguments and the bad behavior. All of that was mixed in and amongst her motives, potential motives for murder were all mixed in and amongst the case for Mr. Rogers in the closing or in the summation as well. So I think the court, when looking at whether there has been potentially no miscarriage, I would ask the court to bear in mind that everything that happened in this joint trial impacted both of these individuals quite clearly. Not everything, but a lot of it that may be a discrete ground for Miss Burgess would also have an impact on Mr. Rogers. Those are my submissions, unless I can be of any further assistance.
Thank you very much indeed. Unless any of my colleagues have a question, I think we might take a short break.
No questions.
No, thank you.
Right, we'll resume in 10 minutes, if we may.
I put you in the breakout room.
Sorry?
They gave us them to move on.
Can't help you, but you can't have this room. I'm sorry about that.
Right. Just before we hear from Mr. Mahoney, we have discovered that Justice Attridge did not, in fact, hand down reasons for the ruling that he gave in January 2020. He's told us that. So there's nothing to discover under that heading.
Thank you.
Yes, Mr. Mahoney.
Good morning, my lord.
Good morning.
I would just like to start by giving an overview of the Crown's case
Yes.
and the various bits of circumstantial evidence. And starting at paragraph 4 of the respondent submission.
Yeah.
And it's the Trinidadian national Marcus Gibbons arrived in Bermuda in 1998 to take up employment with the CCS group. He resided with his wife and 3 children in St. David's. He and the appellant Burgess started an intimate relationship around 2000-2001, which created tension in his marriage. When his wife and children went back to Trinidad, Marcus and the appellant Burgess started to live together along with her daughter Alexis. The appellant Burgess had demonstrated hostility, violence, and possessiveness towards Marcus. She would initiate arguments with Marcus at his work functions, such as Christmas parties and cruises, with her being described as loud and the aggressor. She would accuse him of infidelity while she flirted with other men in his presence and was seen at different locations in the company of other men during the relationship with Marcus. One day when Catherine Fisher, Marcus's work colleague, called the apartment at Derwent Lane to speak to him about a work-related matter, the appellant Burgess hung up the phone on her. Don Sousa, co-worker of the appellant Burgess, said that the latter had expressed concerns that Marcus was cheating on her. Once they argued and she hit him, and she had never complained that he was violent to her. Donna Daly, the landlady of 10 Derwent Lane, and some documents were sent to Mr. Coelho, which we have asked him to include in the cloud and to pass on to the court. Donna Daly's statement was one of those statements that was read into evidence by agreement. Certain sections were agreed not to be read in, which was mainly how the issue started the night when she had to go to the premises. And I will go through and come back to that. But Donna Daly, who was deceased by the time of the trial, said that she was the landlady of 10 Derwent Lane, stated that within a month after the appellant Burgess and Marcus moved into the lower apartment on the premises, there was an incident in which the appellant Burgess called her at around 1 a.m. to come to the property. While Burgess was speaking to her, Marcus took up the bedroom phone and indicated that he locked himself in the bedroom because Burgess was hitting off of him. And he was scared.
That's the passage, Mr. Mahoney, that's the passage that was excluded. So that wasn't read to the jury, correct?
No, this was read. What I is referred to in my submissions was read to the jury. Mr. Robertson had indicated that the section at the bottom that she observed he had a slightly swollen and busted lip was not read to the jury. I beg to differ because on the court smart recording, the disc, which is 4 of 4 at 0-15344, dated the 10th of February 2020. And the timing there is at 1:10 to the end. That was actually part of the evidence that was read to the jury.
You're saying both the passages referred to by Mr. Richardson were in fact read?
Yes, my lord.
Hitting off at him and slightly swollen and busted lip, both read.
And looking terrified.
Yes, my lord. Excuse me, sir?
Before the slightly swollen and busted lip, I think Mr. Richardson told us that the words "look terrified" were excluded.
No, sir. The court smart recording actually has
Right.
a recording of what was read. Unfortunately, I don't know how to play it for the court at this juncture, but it can be verified by Mr. Coelho.
And Mr. Richardson can verify as well.
Yes, my lord.
Yes.
I've done it.
We shall assume what you say is true until told that it isn't, and we will then have to look at, or may then have to look at the court recording.
Very well, my lord.
And when I say and told that it isn't, and told that it isn't by somebody who has actually listened to the court smart recording.
Yes, sir. I understand, sir. I'll move on to the next paragraph. On 2 occasions while Marcus was having a barbecue at Durant Lane, the appellant Burgess arrived and kicked over the barbecue, telling those present on 1 occasion to get the fuck out. Both Burgess and Marcus were given notice to vacate premises at 10 Durant Lane by the 31st of October 2006. And by the 20th of October 2006, unbeknown to Burgess, Marcus moved much of his things into a new apartment at Loyal Hill, the location of which was not disclosed to Burgess. She only found out he had moved when she came home and found his stuff gone. I want to pause there, sir. That bit of evidence comes from the statement of her stepfather at the time. That was Ronald Burroughs, which was read in by agreement. It's in one of the documents that was just sent to Mr. Coelho.
Mr. Mahoney, sorry to interrupt you. I don't see Mr. Richardson. Is he on? Yes, he is. Right. Okay.
And in regards to these statements, there are certain pertinent area of that are relevant to the circumstantial evidence, because in respect of when she found out that he moved out, does your lordship have access to that document from Ronald Burroughs?
Sorry, where am I supposed to find this?
Ronald Burroughs.
Now, where am I supposed to find it?
Mr. Coelho, have you uploaded it in the cloud?
It was sent to me by email, so I've just sent it to the judges.
Oh, it's an email that was sent from Mrs. Kingdean with several attachments, sir. Not too long ago, within the past 5-10 minutes.
Which of these are you referring to, Mr. Mahoney?
Ronald Burroughs, sir.
Okay. Right. We don't want to read which part of it.
It would be page 2 of that statement. In the right-hand corner, it's 202.
Yes.
And it's starting at Katrina would never tell me what her and Marcus was arguing about.
Yep.
So Katrina would never tell me what her and Marcus was arguing about. She did tell me, though, that he has never put his hands on her. One time, I just remembered Katrina told me that Marcus came home drunk and he wanted to argue. In my presence, I've never seen Katrina and Marcus argue. They always looked happy together, and I never saw any signs that they were unhappy. Occasionally, when Marcus would go away and not take Katrina, she would spend a night or weekend at my house with Alexis. Alexis was her daughter. About a week or 10 days before Marcus was found dead, Katrina told me she had given Marcus an ultimatum. She told me that her and Marcus were having problems and that it was either her or the bottle. She told me that Marcus was coming home drunk a lot. I told Katrina that doesn't even sound like Marcus, and I told her that it sounds like something is on his mind. Moving to the next page. Then a couple of days after Katrina told me about Marcus drinking, she said that she came home one day from work and found all of Marcus's stuff gone. I knew that Katrina and Marcus had to move out of the apartment at Derwent Lane, but I thought that they were looking for another apartment to move into with Alexis. The day and the rest is relevant, sir, because it comes down to the circumstantial evidence from the Sunday leading up to the actual murder and when the body was found. The day that Katrina told me that Marcus had moved all of his stuff out was the Sunday before he was found dead. Katrina also said that day that she doesn't want to stay in the apartment by herself and asked if her and Alexis could come up for a couple of days. This would have been Sunday, the 22nd day of October 2006. Katrina and Alexis came up my house that evening, and I believe she had some of Alexis' clothing. The next day, Monday, the 23rd of October 2006, I saw Katrina that evening. She was at my house when I finished work. She told me that Alexis was at her aunt Kendra's house and that she was going to go to the apartment on Derwent Lane to get some clothes before it got too dark. I left Katrina at my house and I did not see her again until Tuesday evening, the 24th of October 2006 at my house. When I saw Katrina that Tuesday evening, 24th of October 2006, she was leaving my house to go to dinner with one of her girlfriends. That's what she told me. Later, one will find the defense read as part of their case the statements of a Vernal Keynes, which I believe is also uploaded. I will come to that later, wherein he was the person that went out to dinner with her, yet she told her father she was going out with one of her girlfriends. This was about 7:30 p.m. Katrina never told me which girlfriend she was going to dinner with. Then Wednesday, the 25th of October, 2006, I did not see Katrina at all that day. However, she called me, it must have been around 7 or 8 p.m. from her job phone to my house phone. She said, I am working late, Daddy, don't wait up for me because I'm going out after work to Lobster Pot to have dinner with a friend, some friends, a guy and his girlfriend, and then we're going out after that. And this is important as well because this is part of when she said she left a message that Marcus was to meet her at her workplace. And then when she left the phone message, she told him she was going to get something to eat. And if they still want to meet up, to meet her at the father's house, when in fact she had no intention of going to the father's house that night after leaving Lobster Pot. She told me, don't lock the door. She told me the guy's name that she was going out to dinner with, but I can't remember his name. I think he used to be a police officer. Then it was between 4 and 5 a.m. I was awake because I had to use the bathroom. I heard the door open or close to my apartment. And when I came out of the bathroom and went to the kitchen, I saw Katrina, who was standing behind me in the kitchen. Katrina looked normal, like she normally looks, a bit tired. In fact, she even said she was tired. The kitchen light was on and Katrina was about 1 foot behind me. She was so close that she put her hand on my shoulder when I turned around. I'll pause here and come back to her statement, sir, as I continue. By this time, sir, there is evidence that Marcus had actually moved out much of his stuff from Derwent Lane. There was the evidence of Nikita Hunt, and that is found in I don't think there is any issue with our evidence, as was summarized by the court. Nikita Hunt is found in volume 1, tab 6. But I will just go with the summary I have here, sir. Continuing at paragraph page 4 of my submission 9, Marcus had moved on and started a separate relationship with another lady who visited him at the Loyal Hill apartment on the 13th and 21st of October 2006. He had removed the picture, and I paused there. Based on Ms. Hunt's evidence, on those 2 occasions, they had sex. They were intimate with each other on those occasions. To put everything in context, sir, I would just pause right here and draw your attention to some emails. Ms. Mulligan made reference to some emails that were tendered into evidence by the defense. It was in cross-examination, I think, of Mr. D.C. Sabian that Mr. Richardson had asked him if there were some cards that were seized from the residence that were love cards between the appellant Burgess and Marcus Gibbons, as well as some email taken from his cell phone. The emails, I believe, are relevant because it assists the court in understanding the state of the relationship that existed just before Marcus moved out of the apartment to the Loyal Hill residence. I take the court to the Record of Appeal, Volume 2. At page 577. And these are email chains, so I'll have to read from back to front. So at the bottom of page 576, there is an email from Marcus Gibbons to Katrina Burgess, dated Thursday, August 24, 2006 at 1:14 p.m. And the subject was me. He said, the black case I take to work does not have, oh, sorry, I should have started at 577, sorry. There was an email that Ms. Burgess had sent at 12:59 p.m. wherein she said, the movies you have at home in your CD case that you take when you go out, ring a bell now? Why do you reply to half the stuff I mentioned? The problem is with your verbal abuse that you said you would try and change, so you know it is a problem. That's where my attitude is coming from. The difference between me pushing you away and you pushing me is you're quick to recover from yours like it's temporary and act like all is okay, like when you want to have sex. Mine, on the other hand, is not. His response at 1:14 p.m., the black case I take to work does not have any movies in it. It's a small black case that has music in it, which has been and always stay at the house. When you go poking around in my stuff, make sure and get it right. Michael asked me to put all the bits of movies all on 1 or 2 discs, which he got from someone who wanted him to sell it at the shop. Those movies have been there for over a year now, and you still don't seem to get it. When I start shouting at you, it's because I'm tired of dealing with your lies. You not being honest and taking advantage of me. That's how I've been feeling for the past month. Don't forget, you also said you would try to get rid of your insecurities and jealousy, which always causes you to treat me the way you do. I don't see that changing. If you think you can't, then we should go our separate ways, because it's not working and I've had it with your attitude. Ms. Burgess responded at 1:21 p.m. on that day. Like I said, reply to everything I have mentioned. You would if you are talking face to face. I agree, it's not going to work if nothing changes. And as I said before, you don't seem like you're willing to change because you haven't tried since we talked about the verbal abuse. I think you want out for other reasons, and you are using your attitude as an excuse. With the way you have been treating me, I should have attitude. Remember, even with my so-called attitude, I still don't talk to you the way you talk to me. Bold letters, I am not the only one who has to change. You agree to that. He responded at 1:39 p.m. It seems strange that I'm getting your emails now when I couldn't seem to get them before while I was getting other emails, just a thought. Her response, very, since Laurie was getting my emails just fine. And later we'll realize that Laurie was her best friend who was a co-worker of Marcus Gibbons at the CCS group. Moving on to page 568. At the bottom, email dated Monday, September 25, 2006, 9:53 a.m. Marcus Gibbons to Katrina Burgess, subject us. I can't understand why you are down on me for not saying much. And yesterday you walked right out and not say anything. What's going on? You put the ball in my court and then you act like I should be the one to make everything right. I thought you were looking into finding someone for us to talk to about our problems. Then you tore up any picture of me and the scroll you gave me we had in the house. What's up with that? A response at 10:07 a.m. is, I'm ready to go my way. You said that is not what you want. The ball is in your court because of the way you have been treating me the last few weeks. Plain and simple. If it is not what you want, then you have to show me that. If it is, then let me go. I tore the pictures up and the scroll I gave you because as far as I was concerned, you had 2 weeks to show me that the decision I made is not what you want, and I have seen nothing. Instead, you have been going about your business as usual. As for the scroll, you are not the man that scroll describes. You have become someone else. As for finding someone, I have, but I didn't bother to tell you because I'm waiting for you to show me that you don't want it to be over. If you're still acting the same, then why should we talk to someone? I left the house without saying anything because I am still pissed at how you're acting, which is not like someone you want me. The more you act like that, the more I want this to be over. I pause, sir. There is another witness, well, a witness who came live for the defendant, the appellant Burgess, her aunt Kendra Place, and her evidence was pretty much in line with her statement, which is included in the email attachment.
Sorry, what was the name of this witness?
Kendra, Kendra, sorry, not Place, Kendra Wharton. This place is in my office. It's Kendra Wharton.
Sorry, do we find her statement somewhere?
Where does it, sir? Yes, it's an attachment in the email that was sent with Ronald Burroughs, the last email that was sent with the attachment.
There he is. Mm-hmm.
And I will just quickly deal with her evidence so that as I go on, you will see everything overlap. So Ms. Wharton came and she gave evidence in person. And in a nutshell, she said that the daughter, Alexis, that the defendant, Burgess, actually brought Alexis to stay with her. I think it was a Monday. And Alexis was with her throughout the course of that week, which was the week when the murder occurred and the body was found. And I think that was, that witness was called to contradict the evidence of a Ruby Landy, whose I will come to, because Miss Landy said that she saw Miss Burgess and the daughter Alexis on the morning of the 25th of October, which was the day before the body was found, when they were heading to Miss Burgess's car, and Miss Landy was checking on her mother's premises at Berrent Lane. I will come back to that, sir. But the relevant portion that I wish to draw your attention is at page 1 at the bottom. I did know, the last paragraph, I did know that Katrina and Marcus were having problems, mostly to do with alcohol and going out. Both of them used to drink. I do remember a few months ago, I advised her to get counseling if she was going to make the relationship work. I was happy to know that she was going to take my advice. And then she said that Marcus decided that he didn't need it. I know that Katrina loved him very much. When they were always around, they never had a harsh word for each other. The relevant portion there is, sir, from what we have seen in the email, Marcus was interested in getting the counseling. She wasn't. Yet she told the aunt that Marcus was not interested. Over to the next page, Ms. Wharton's statement. And this is where she spoke about the week of the 21st to the 28th when Alexis came over to her. I'm trying to find the next paragraph. The second paragraph on the second page, which said, I also remember that they had to vacate the house and she hadn't found an apartment yet. I know that she said that Marcus on Sunday, the 22nd of October, 2006, had gotten up in the morning and was packing up his belongings, which is not true. Katrina was surprised because he never told her that he had an apartment. She said that they didn't have no argument or nothing, and he told her he would call her later before he left. I knew that she was hurt about this. So on the father from Ronald Burrell, she told the father that she came home one day and found out that he had moved out. Yet she told her aunt that he just woke up the Sunday morning, packed up, and just moved out. But the relevant thing is that she indicated, well, the aunt indicated that Miss Burgess was hurt that he moved out on her. And that is as much I need from Ms. Wharton's statement. I'll go back to the email, sir. So I'm back at page 568 of the...
So sorry, she told her, this is her aunt, is it?
Yes, sir.
So she told the aunt that he got up on Sunday the 22nd and
Yes,
started
sir.
packing his belongings. And she told her stepfather, just remind me.
The stepfather, Mr. Burrell.
Yeah, I know. And what was it she told him? Just remind me.
She told him that she came home one day and noticed that he had moved out. This is at the top of page 3 of the stepfather's statement.
But was that day the 22nd also?
No, she told him on the Sunday before he died, the 22nd, that she came home one day and noticed he had moved out his stuff one day from work. Yet she told the aunt that she woke up on the Sunday morning, and Marcus just got up and packed up his stuff and moved out.
Oh, I see. Yeah. Okay.
Yes. So at page 568, continuing on with the emails back to September 25th, 2006, at 10:35 a.m., Marcus Gibbons responded to Ms. Burgess. I'm sure you feel that way. It was never my intention to hurt you. I have that same empty feeling that you have right now, And it got that way because of how you treat me when it comes to not trusting me. You don't know how much that affects me. It seems that you don't ever believe anything that I am telling you. I know I'm partly to blame, but for the way things are, but if you feel like you are ready to go, then I think you should, as it makes no sense to still be here and feel that way. As I told you last week, I'm prepared to work on it, but why aren't you acting like you feel the same? I cannot understand what else you want from me. I don't know what else to say. And her response from the bottom of 567, the response is actually at the top of 568 is, I want you to act like you want me and treat me accordingly instead of shutting me out. I have not seen that from you, and that is why I feel like I did. Continue at 567, he responded at 1:49 p.m. and asked, what about the pictures? Her response at 1:50 p.m., pictures can be reprinted. If we stay together, you have them saved on the computer. If not, it's no big deal. His response at 1:57 p.m., it's the action that counts. I guess it's no big deal to you. That says a lot. Her response, 1:59 p.m., I felt the same way when you threw away my cards I gave you. I guess we both have a moment of throwing things away when we feel disgusted. 5:66 at the bottom, Marcus responds at 2:05 p.m., which is at the top of 567. And you were disgusted because you assume I was out with another woman. When is it going to stop? Ms. Burgess responds at 2:09 p.m. Do not change this around. I saw who you were out with when I was upstairs, unbeknown to you. Read about 4 emails down. I told you why. Stop jumping to your own conclusions. Then his response at 2:29 p.m. I was hanging with a lot of people Saturday and there was nothing going on. Are you sneaking around to see who I'm hanging with? Why did you pick now to tear up the pictures? Her response at 2:33 p.m. The point is I went upstairs and someone pointed you out to me, unbeknown to you, meaning you did not see me when I was up there. I told you why because of the last 2 weeks. At 2:39 p.m., Ms. Burgess sent another email. I don't have to sneak anywhere. It's a free country. I can go where I like. And if it so happens to be the place you are, think what you like. Continuing at 564 at the bottom. Sorry.
What are you showing these sequences of emails to us to show?
To show the actual state of mind or state of the affair between both and the state of mind of the defendant at the time when he moved out.
Right.
Because in a nutshell, this is my submission and you will see what I'm saying shortly. Continue at 561. But in a nutshell, she was given an option. We either go along together or I move out. Whereas Marcus created his own option and he moved out, which hurt her, as per what the aunt said. So at page 561, says Wednesday, September the 27th, 2006 at 10:26 a.m. Miss Burgess to Marcus Gibbons, you pissed off because I didn't call. I was out late and probably because I slept in the bedroom. Now you know how I felt all the times you did it. Doesn't feel nice, does it? No need to reply, just wanted to point that out. Then on September 29th, this is at page 559, and I'm coming to an end shortly, sir. The email. At page 559, at the bottom, Friday, September 29, 2006, 10:01 a.m. Ms. Burgess to Marcus Gibbons, since our conversation 2 days ago when you hung up on me, am I to assume that you are not willing to try the list idea and that you don't want this because you never said you change your mind or not? I still want this, but you know me. I'm not staying where I'm not wanted, and I'm not going to ask you to change your mind either. The reason I'm asking is because if we are not going to try and make this work once and for all, then the sooner I'm out of the house, the better, and I will start packing. His response was at 12:34 p.m. I didn't hang up on you, I just didn't say bye after you did. Your problem. That is, you don't know how to express yourself or relate to me, and I don't know how to relate to you anymore. Take example in your email to me. It says that you still want it. You are not staying where you're not wanted, and you're not going to ask me to change my mind. What are you really trying to say? Is it that hard for you to say this or anything relating to your feelings about me to my face? If you have trouble expressing yourself to me, then how do you think this is going to work? I have gotten to the point where it's hard being in the same house with you. It's really affecting me and you don't see it. While you were hanging out last, were you thinking about me or saving the relationship? But now you seem so concerned. And this is the last email, sir, at the top, 1:04 p.m., where she said, no, it is not hard for me to express myself. First of all, you make it difficult to say anything to your face, especially when I'm being serious and all you do is laugh or lash out. Not to point fingers, but you haven't exactly been expressing yourself either as far as how you feel, except for the bad things. I told you weeks ago the ball was in your court, and I needed for you to show me that I am still what you want. As far as hanging out, from what I could see, you weren't thinking of me or saving the relationship either, especially with what you said to me while I was out. Trust me, I do see how difficult it is to be in the same house because I feel the same way, which is why I choose not to come home until late. Which is why I suggested that if you don't want this, then I will start packing. I wouldn't call it being concerned. I call it dealing with it once and for all instead of being silent and playing guessing games. Like I said earlier, you never said if you change your mind or not. I'm tired, as I mentioned weeks ago, and either I move on or we move on. I refuse to go another 2 weeks like this. I will move out first. And from there, I wish to draw your attention to the photos, which is in Record of Appeal 1. At page 13. Yeah. I will just go through all the photos at one time, sir. Okay. But the upshot of this is from a combination of evidence from his friend Khalid, I think his Khalid Pitcher was his name, and Nikita Hunt. There was evidence that Marcus had actually moved his stuff out, much of his stuff out from the Derwent Lane apartment mid-October and was actually living there, essentially. So starting with the photographs at page 13.
Sorry, and was actually living where?
He was actually living at his Loyal Hill apartment.
Quite.
Right.
Yes, sir. Which would have been contrary to what Miss Burgess was telling her stepfather, well, telling her stepmother that he just woke up on the Sunday morning, the 21st, and started packing.
Well, well, the 21st of October is late October, and then don't understand the discrepancy.
Yes, sir, but that's not so. He had already moved out because Miss Nikita Trott, said she was at his apartment, the Loyal Hill apartment, on the 21st of October. I think she was going netball or something. And she went there and they had sex, and then she went back home. And I'll come back to her because she was a married lady at the time. And part of the defense, the appellant's case, was to infer that probably it was the jealous husband who could have been the murderer.
Yes.
At page 13, this is 13 Derwent Lane.
Yes.
And the vehicle in the background, that was Marcus Gibbons' CCS van that he drove, his work van.
Yes.
At page 14 shows the entrance, the layout of downstairs of Derwent Lane. And just to add, made reference to Miss Ruby Landy earlier, sir. If you look at photograph, page 14, the photograph there, you will notice close to the right of the photograph where there is like an air conditioning unit. Like there's a little passage that runs adjacent to the driveway.
In the shadow.
In the shadow.
Yep.
Yeah.
That's where Ruby Landy said she was in that area when, on the morning of the 25th, when she passed Miss Burgess and her daughter going to the car. And Miss Landy and Miss Burgess, they knew each other from before. They used to go to school together back in the day and so forth. But I will come back to her evidence. But this is the apartment is a downstairs apartment. There's a sliding door to the downstairs apartment. The couch is on the reverse side of that sliding door. And they would enter the apartment through this door that is open. Page 15 shows the door some more. And going over to photograph 17 shows the entrance into the apartment. I skip to photograph 26. If you look at photograph 26, you'll notice that once you enter the door that was opened, to the right of that door is a living room, which is where the couch would be. And you'll notice the blinds covering the sliding door that we saw in the earlier photograph. At page 30.
Page what, sorry?
Page 30. That's a clearer view of the blind.
Right.
Behind the couch. And I think Ms. Mulligan had pointed out the plant. So we see the plant there.
Yes.
But there is sufficient space behind that particular couch because there is a tripod. I think it's a camera or astrology type equipment behind it. At page 36, no, page 36 is another view of the living area. The tripod is at
53.
Yes, sir. So you could see the tripod and the plant, and there is some space between the plant on the ground. There are space to the left and the right of the plant. That anyone could walk.
Mahoney, could I just ask? Do I correctly recall that there was no sign of a forced entry?
That is so, sir.
So how did the murderer enter the premises in the absence of the deceased?
Well, sir, we can't say, sir, but what we know is that on that particular day, Miss Burgess, her colleagues at the office observed that she was behaving rather suspicious. In other words, or she came to her dress. She told one person she was moving house that day, which was a lie. Because the next day, before the body was found on the next day, she requested of the landlady an extra, some extra days because she couldn't find anywhere to move.
I'm not sure that deals with what I'm asking you.
She was in and out of the office, sir. So it's either the person got
I'm
a key
concerned
or
with what she was
or
doing.
not.
I'm
Excuse me,
concerned
sir?
with how the killer got into the apartment ahead of Marcus.
Sir, I'm unable to say, sir, and that's why the inference the jury would have to draw the inference based on Miss Burgess' activity that day, sir.
Would he have needed a key?
He would have needed a key, sir, or
No evidence of that. There was
the
no evidence
door
of
could
that.
have been left unlocked. I don't know, sir.
Right.
No, this is speculation.
So I'm sorry, sir, but to really give you a definitive answer would be speculation, as Mr. Richardson said, sir. But somehow someone was inside there. At 53, 54 shows angle from the living room going back towards the kitchen dining room area. And that's relevant, sir, because where the couch is located, if the person enters through the door, the entrance door, if someone is in the living room area, they will be coming from the right to the rear of that person. If the person just enters and goes straight in. And this is relevant to where the witness said when Ms. Card said that the appellant Rogers told her that he got in from behind, which when you look at the configuration of the apartment and where the couch is and where he said he was hiding, it is not inconceivable that he would have surprised him.
How many exterior doors are there into the apartment?
Just the sliding door and that door. I could show you the exterior of if you look at page 16, sir.
16?
Yes, sir. So if you look at page 14.
Yes.
You have that entrance door and you have the sliding door behind the.
Yes.
The sliding door has the blinds down, and if one went in that way, you'd walk straight into the couch, would you?
That is so, sir.
I'm not quite following your latest point. If you look at page 14, well, let's look at page 17. There is the front door. If you walk into that, the front of your body will face anybody who's in the kitchen. If you look at page 16, sorry, page 26, if you've walked some way into the kitchen, anybody who came from behind the couch would be behind you.
Yes, sir.
But if you hadn't walked far into the kitchen, anyone who came from behind the couch would be in front of you.
Yes, sir. But one have to look at the dynamics of what happened, because if the person was standing right at the door, more than likely Marcus would have run away. So clearly the person, and this is something that the jury could infer, and I believe they inferred, clearly the person waited until when Marcus entered, took a few steps in, then they jumped him from behind, and the struggle started from there. And that's why the initial struggle, there was a chair in that vicinity that appeared to be knocked over.
Yes.
So if he was hiding behind the couch, one would have heard the vehicle coming down the driveway. And you will notice that the vehicle was parked with the front facing up towards the main road. So one would have heard the vehicle reversing and coming down, and it's easy for whoever was there, if they were behind the couch, to take up position so that as he opened the door and took a few steps in to attack him before he had a chance to realize that someone else was in there. But to answer Justice Kay's question, if you look at photograph 16, and we are focused on the downstairs apartment, there are no other areas of entrance to the apartment. The windows just above the hose on the ground, I think that's where the dining room table is. And there's another set of windows, slightly hidden by the palm tree. I think that's the master bedroom. Where the body was found in the apartment, at page 21. And page 24. '23, 24, right in ahead. I think that's a bathroom. And to the left of where the body was found was a master bedroom. To the right of where the body was found was the daughter's bedroom. In respect of the bedrooms, if one looked at '42, is a master bedroom. And in 43, you notice that one section of the closet is empty. And the other section of the closet, the section closest to the bedroom door, which is shown in 44, has stuff there and appear to be women garment, women clothing, and so forth. At 44, you're looking straight across to the daughter's bedroom. And the daughter's bedroom is at 46, 47, 48. 4950. So apart from the sliding door, there was one way in, one way out. If one look at page 57, this is the Loyal Hill apartment that Marcus Gibbons had removed to.
Just before we get to
Yes, sir.
that one, could we go back to page 17 of these photos? Because it's apparent from 17 and 18 that there was blood at the entrance to the apartment. In photograph 18, one can see presumably stains at 1, 2, and 3, and blood on the carpet at the very entrance to the apartment, which is presumably tab 4. I had understood, and further, if you go on to photograph 19, there's some rather more blood on tab 5. I had understood the expert evidence to indicate that the first wounds had been made when the victim was just within the apartment, so that some blood was able to be spattered out outside the apartment, presumably items 1, 2, and 3. How would that fit in with the proposition that it all started by the murderer coming from behind the couch and from behind the victim and attacking him when he got some way into the kitchen?
My lord, what the evidence is that he hid behind the couch. Not that he was behind the couch when he entered the room. He may have hid in the apartment. He may have hid behind the couch. And as Marcus was entering or unlocking the door to enter, he positioned himself. And as he took a step or two, he jumped him at the threshold. That is the evidence I understand of the expert, that the attack started in the area of the threshold, the entrance of the door, not outside. And I think Miss Mulligan was at pains to try and in cross-examining the expert, and she was adamant that the attack did not occur outside. It started on the inside and moved to the area of where there were much footwear in the blood, and the body eventually collapsed in that area.
But okay, assume that. But if that's what I had understood the evidence to indicate, the attack started at the threshold of the door, that is to say, just when you've gone into the room and not when you're on the paving outside. But on that footing, how is it that when the attack began, the man who had previously been behind the couch had got behind the chap who had opened the door with the key?
My lord, it's circumstantial evidence, sir. And if you look at all the evidence, at the blood splatter in the whole area, on the fridge, in that general area as well.
Well, that doesn't answer my question, which is how the blood, I'm not interested in the blood splatter by the fridge for the moment. How is it that the blood spatter at the very entrance, just over the threshold, indeed sufficiently close to the threshold that some of it actually is thrown out to beyond the door, how does that fit in with the proposition that the murderer, having hidden behind the couch, came and met the victim at the door?
That's what I'm saying, sir.
Well, sorry, how does that fit in with that? But how does that fit in with the proposition that the murderer attacked the victim from behind?
No, not attack, jumped him from behind, sir. Doesn't mean that he cut him from behind.
You said otherwise.
He started the attack from, well, he came up behind him, so he got him from behind, and then the struggle started. Based on the blood, could Mr. Richardson please mute and not interrupt me? You'll have a chance to respond.
I was actually going to raise an objection, but okay.
I'm making my submission, sir. I didn't interrupt him.
My lords, I'm sorry. If
Can I proceed, sir? Or
I have some
either you've
concern
got
with the
an objection or
process.
you haven't. If you have
I
an
do have an
objection,
objection,
tell
sir.
us what it is.
I have an objection, sir. I do have some concerns with the process that Mr. Mahoney is now following by going through the photos and giving you his own narrative when there are ample witnesses who were called in this trial who did testify as to what the photographs did or didn't mean. This is a very unfair way to do it because there's a lot of stuff being smuggled in here that wasn't in evidence before the jury. A lot of Mr. Mahoney's opinions and views. It was complete speculation that the murderer got there first.
well, my lord, I will to all of that, sir. This is evidence that was before the jury, sir. The photographs were there. There was evidence from Miss Card, and those were the evidence before the jury, sir. And it was from the evidence, sir, and this is our case, sir. I'm going through the Crown's case, that he was ambushed when he entered that apartment. And it is borne out from the evidence of the photographs and Miss John Johnson, which indicated that the attack commenced at the entrance of the apartment. In other words, once he entered the apartment, the attack started there. So my learned friend can say whatever he wants to say. That is the evidence that was before the jury. And
I follow that,
yes,
but think of the position of the persons. The man who is coming in from the door would have his chest towards the kitchen. He wouldn't walk in backwards, would he?
It's a slight angle, sir. If you look at the entrance and the chair, you wouldn't walk straight ahead, sir. Because if you look, is the dining room, as you open the door, there's a dining room table at photograph 17.
Yeah.
So once you enter, you have to make a slight angle to your right if you're moving towards the bedroom area or thereabouts, sir. Photograph 19, would I say, sir?
Yep.
But you'll notice that the chair that, well, there is no chair there at number 5, which would suggest a struggle started in that area. And one of the chairs got toppled over because there is a chair that you could infer would have been at 5 was moved from where it was, and the one on the side was toppled over in photograph 19.
Yes, well, I can see that upon the footing that coming into the door and going into the kitchen and avoiding the table, the victim might have moved to the right, which might have meant that the assailant attacked him from behind. Still not quite sure why that would produce. I can see that might produce blood at 0.5, and it's slightly difficult to see why it would produce blood at 0.4, and a fortiori blood at points 1, 2, 3, and 4.
I will come back to the photograph 26, may I say, sir?
I didn't hear what you said.
No, I was saying photograph 26. When I said that once entering the room, he would move slightly to the right at an angle because the dining room chair and table is right exactly in front of the door.
Yes.
So at photograph 26,
yes,
if you enter and you're coming in, you would move slightly to your right, and the couch and the living room area would pretty much be to the back of your right shoulder.
Yeah, I'd understood that. That was the point I said I'd understood. The point that I said I hadn't understood was why, if that was the trajectory of the murderer and the victim, we find blood at points 4, 3, 2, and 1.
So it's possible that during the struggle, he attacked him, the struggle is there, and some blood came out at that point. But I will go through that particular portion when I'm dealing with the evidence of Ms. John Johnson.
Okay.
And Mr. Mahoney, just to indicate that the victim and the murderer must have moved around somewhat. One sees from 19 and 21 the chair that was knocked over, but there was another chair which would be closer to the door, which was not knocked over.
That is so, sir.
Just before we leave these pictures, it's apparent that the victim was, let me just find it. I think he had his hand on the telephone. Is that right? Well, the telephone was, if you look at paragraph, at photograph 25 and 26, one sees the telephone line coming down to his body. I don't know where the actual telephone was. Whether that meant that he was desperately trying to phone someone, or conceivably that he grabbed onto the phone to try and keep himself upright, I don't know. What was there any search of the phone? This phone.
Sorry, sir. I think there was some evidence of time on the phone. I have to double check the cross-examination of Mr. Eric Woods.
Right.
But I think there was some, he was questioned about the time on the phone or something like that, sir. I'll double check that portion, sir.
Well, that might be useful because, I mean, if he didn't make a phone call, there wouldn't be any evidence of a time. And it's pretty unlikely that he made a phone call in the middle of being attacked and bludgeoned to death. But if there was evidence of time, it would put the actual time of the murder.
No, there was no evidence of any phone call, sir.
No, okay, right.
And that's why we were not able to say what time the murder occurred.
No, I follow. Sorry, I distracted you from showing us.
Well, I was going to page 57, the Loyal Hill apartment.
Uh-huh.
And 57, 58, 59, 60, 61, all show that he had actually moved in, made himself comfortable in this new location. '66 shows his clothing in the closet. 67, 68. So going back to page 4 of my submissions at subparagraph 9.
This is 8 Foothills Road, Devonshire. Is that the same as Loyal Hill?
Yes.
Yes, sir. That's what it was referred to. Look, throughout the evidence, sir.
Right.
Apparently, it's in the Loyal Hill area, sir.
Sorry?
Apparently, it's in the Loyal Hill area. So,
Oh, I see.
what it does refer to it as the Loyal Hill.
I follow. Yes. That's what I had assumed.
So, continuing at page 4 of my submission, paragraph 9.
Mm-hmm.
Mid-paragraph, he had removed the picture of Burgess that he always displayed from his desk. And he also shared with his colleagues at work that he had a new girlfriend. And I indicate that Miss Laurie Hudson, Burgess's best friend, also worked there. Scott Lauder stated that on Wednesday, the 25th of October 2006, at about 7:15 p.m., Marcus told him via telephone that he was going over to the old house, meaning Derwent Lane, to pick up some things and to talk to Katrina about a few things. Marcus stopped by the residence. Well, there is a phone call in I will come when I'm going through the phone records. I will show you there's a record of Marcus calling Scott Lauder at actually 6:54:40 p.m. that day, but I will come back to it. Marcus stopped by the residence of his friends, the Pears, at Ramboat Hill to fix their computer. While he was there, Burgess called him on his phone, 7:51 p.m., and asked him where he was and if he was still coming over. Mrs. Pears said that she heard Marcus said, "I'm just finishing up something now and I'll be there in a while." After the call, Marcus confirmed that he was supposed to meet Burgess at the house tonight, and he left their residence at about 8 p.m., driving his CCS work van. Mrs. Spear drove out behind him to go to the store. Marcus traveled along Harrington Sound Road, heading west, and Mrs. Spear turned onto Knapton Hill. That was the last time Marcus was seen alive or heard from. Just to respond to Mr. Trevington, sir. Mr. Richardson had indicated that on that night, there was, Marcus had made arrangement to meet Nikita Hunt that night. That is not so. If one look at volume 6 of her evidence, the cross-examination, page 52.
All right.
Sorry, which page?
Page 52, line 23.
Yeah.
Well, just some quick background. Mrs. Hunt was married with 2 daughters, lived with her husband and her family in Warwick. And she met Marcus, I think, through a friend, somewhere thereabout in September, October, thereabout. And as I indicated earlier in her evidence, she said that he took her to the Loyal Hill apartment in mid-October, and they had sex there. And then on the 13th, and she went back on the 21st when she said she was going to netball practice or something. And then they had sex again on that occasion. So you will notice if you look through the email evidence, after that last email that I read to you from Ms. Burgess to Marcus Gibbons, all the emails thereafter were between Nikita Hunt and Marcus Gibbons. Ms. Hunt, on this particular occasion, she left her husband at home with the children and she went to buy grocery or something. I think she went to a store in the Warwick area. And it was during that trip that she spoke to Marcus on a call. Mr. Richardson made reference to a 40-minute call. So I'll start at line 14 of page 53 of her evidence. Thank you. And that conversation, I think you have already said, lasted for over 40 minutes. And during that conversation, Marcus was trying to arrange to see you, wasn't he? Yes. He never told you that he had any plans to go anywhere to meet Katrina Burgess. No. He never said that to you. No. In fact, all he was interested in was getting at you, I guess. Yeah, he was even trying to get you to come to his apartment up Loyal Hill. He didn't try to get you to come to the other place? No. But you knew where the other place was? Yeah. Did you ever tell your husband where it was? No. You sure? My husband didn't know anything about it. And during that conversation with you, Marcus said to you, didn't he, that I'm going home to my lonely house? That conversation ended about what, 10 to 8? Sound about right? Yeah, I guess. We talked from 7:30 to about 8:15, yeah. And you clearly took that to be a reference to his house at Loyal Hill. Yes, because that's the only house I know where he lived at. Yet Mr. My learned friend was suggesting to the court that he had made arrangement to meet Nikita Hunt at Derwent Lane, or possibly it could have been Derwent Lane, when in fact that was not so. And in any event, she didn't meet him because she went back home, as she indicated, and she called him at about 10 while she was having her bath and didn't get any response from him. And I'll come back to that when I'm going through the telephone records.
Well, yes, up to a point. I'm getting lost.
Sorry, sir.
Well, what is the date of this conversation?
Oh, the date of the conversation is the 25th of October. This is while Marcus was at the piers.
Yes.
I think he got a telephone call. I'm not sure who called whom, but he was speaking with Nikita Hunt for about 40 minutes. This was before he got the call from Miss Burgess at 7:51 p.m.
I don't understand that in reference to the conversation from 7:30 to 8:15.
But I think her time was a bit off in regards to the length of that conversation. I could go to the telephone records now, but I just wanted to.
You do it in your order.
Yes, I wanted to just deal with the records at one time.
But it's not in dispute that this happened on the 25th.
On the 25th, sir.
I thought you were saying that Mr. Richardson had got it wrong.
No, he was, sir. Sorry, sir. What he was suggesting is that Marcus had made an arrangement to meet Nikita Hunt.
Yes.
Said it in such a way as if to suggest made arrangement to meet Nikita Hunt at Derwent Lane.
Yes.
That is not so. He was trying
I
to get
see.
her to meet him to come to Loyal Hill, which she said is the only place she knew.
Yes.
But in any event, that didn't happen.
Well, that's what I had thought the evidence to be that at this time there was a conversation with Nikita Hunt in which there appeared to be a reference to Marcus going to Loyal Hill, which was said by the defense to be inconsistent with the proposition that he arranged to meet Miss Burgess at Derwent Lane.
Yes, sir. That wasn't an arrangement. He was trying, the suggestion put, as I just read, he was trying to get her to agree to meet him at Loyal Hill.
Right.
But that didn't happen. So there was no arrangement in place, as was asserted by Mr. Richardson.
Oh, I see. So the error was to suggest that there was an arrangement rather than a suggestion.
That is so, sir.
Yes, I'm sorry. When you say Mr. Richardson got it wrong when he said, I wasn't quite clear which aspect of quite a long sentence, as it were, of Mr. Richardson you said he'd got wrong.
Oh, I'm
Right.
sorry, sir.
Okay.
Yes, sir. In respect of when he left, nobody knew what time he arrived. I noticed that my learned friend, Miss Mulligan, seemed to suggest that he should have reached Derwent Lane by about 8:30. Nobody knew. In respect of that, Miss Mussenden Pier.
And Mr. Mahoney, I mean, it struck me when Miss Mulligan said that half an hour to get from the Pierres to Derwent Lane was perhaps a little on the long side.
Yes, sir. But nobody knew what time he got there. Nobody knew if he stopped. I
Right.
think Miss Mussenden Pier at should be.
We left at about 8.
Excuse me, sir.
He left.
He left
round-
at about 8, and at volume 1 of the transcript, tab 2.
Yes.
Page 40.
This is Mrs. Pierre, isn't it?
Yes, sir. Line 1. Sir Richardson suggested to, questioning Mrs. Mussenpier, you were sure he was going to Derwent Lane. That's where you, and she said, that's where he indicated to me that he was going. Okay, and then she said, and I must say that the reason I may have said he was going to his new apartment, he may have wanted to stop there on his way. He may have mentioned to, stopping there first and then going on to meet her. So there is some evidence that he may have said he was going to make a stop. He didn't leave from Mustn't Pier residence to go straight to Derwent Lane. So any suggestion that he would have reached Derwent Lane by 8:30 is actually speculating, because we don't know what he did after he left the Pier's residence at around 8 p.m. Continuing, sir, at page 5, well, suffice it to say, sir, that in respect of Miss Burgess, and as to what transpired that evening, I'll just read through everything and then I'll come back to the finer details of it. So at page 5 of my submissions, at number 12, Marcus was to meet up with friends later that night, but they never heard from him. I think Scott Lauder mentioned that, as well as the witness Richards, and I think Pitcher. His new girlfriend was expecting him to return her call. He never did. And that's what Miss Hunt said. She was in the bath for close to 2 hours waiting for him to return the call. He never did. And on Thursday, the 26th of October, 2006, at around 12 noon, Marcus' co-workers found him dead, lying in dried blood on the floor of his old apartment at 10 Derwent Lane. He was dressed in the same attire he had on at work and was last seen wearing on the previous day with his shirt still neatly tucked into his pants. Marcus was still wearing his expensive watch, as well as his wallet containing cash and credit cards was in his pants pocket. There was no signs of forced entry. There was a butcher block in the kitchen and all the knives were accounted for. In respect of the content of his wallet, that's a photograph, page 73, Record of Appeal, Volume 1, as all the content of his wallet.
I'm so sorry. What was the reference?
Record of Appeal, Volume 1,
yes,
73.
Thank you. Yes.
So it had his bank cards, cash, credit cards, and he was still found wearing his expensive watch.
Yeah.
Moving on at 15, I already went through what Mr. Burgess said. 15, 16, page 6 of my submission, sir. 17.
Yep.
So this is after the body was found. Camille Evan, Burgess's neighbor, who lived right across from number 10 Derwent Lane, said that on either Tuesday the 24th or Wednesday the 25th of October, she saw Burgess driving her green car out of 10 Derwent Lane very early in the morning. The sun had not come up as yet, and one could hear the tree frogs. It was not Burgess's usual time to leave out, as she normally drove out at about 8:30 a.m. That was relevant because I think in regards to her statement to her stepfather, Ronald Burgess, I've read it to you before when he said the day that Katrina told me that Marcus had moved all of his stuff out was the Sunday before he was found dead. Katrina also said that day that she doesn't want to stay in the apartment by herself and asked if her and Alexis could come up for a couple of days. Yet there is some evidence that she was actually frequenting the apartment at some odd hours. And it was part of our case that she was actually starting to lay the groundwork for her alibi. At 18, Ruby Landy, who was checking on her mother's apartment at 10 Durrant Lane, saw and greeted Burgess as she and Alexis were leaving their lower apartment at 10 Durrant Lane between 7:20 a.m. and just after 8 a.m. on the morning of Wednesday, the 25th of October. Burgess's co-workers at Seaboard Overseas observed some unusual behavior on Wednesday, the 25th of October. Casual attire, I'm at 19, sir, page 7. Casual attire was only allowed on Fridays, and Burgess was usually smartly attired. However, she was observed casually attired on that day. One co-worker described her wearing jeans, sneakers, and t-shirt. Burgess left the office on at least 2 occasions for a couple of hours, which was not normal behavior for her to leave the office for so long during the midweek. She told Sarika Richardson that she was moving house, which I already indicated to you, sir, that is contradicted by the photographs showing that she was still at Durrant Lane, and in fact, she requested additional time to move out on the morning, just the day when the body was found, but before the body was found. Mario Real Lijo, that's a cleaner, arrived at Seaboard Overseas at around 8 p.m. that Wednesday night to do his regular cleaning of the office. He observed several unusual things. Burgess was at her desk, sitting in close proximity with a man he did not know, later identified as her friend, Vernal Keynes. She was not working. Keynes and her were talking. There were 2 cups and an open light green glass bottle on her desk. Burgess was dressed in jeans, 3-inch shoes, and a dark beige blouse, which was open, exposing her breasts. Before the cleaner started to collect the trash, she brought her trash to the kitchen and put it in the dump and returned to her desk, which was unusual as he normally collected the trash from her desk. When the cleaner went to her desk, she spoke to him about his daughter and personal stuff for about 20 minutes. Mario thought this was strange, as she had never spoken to him that long in all the time he has worked there. Mario also found it strange that she was in the office at that time.
Mr. Mahoney, that again is the passage that Mr. Richardson says the transcript doesn't back up.
I am about to go there, sir.
Okay.
In regards to that, I draw the court's attention to volume 9.
Tab 9 of volume 1.
Yes, sir. Mr. Richardson brought the court's attention to, I think, up to page 20 or thereabout.
17 and 18, I made a
Yes,
note.
17 and 18. And if we were to pick up at, well, this is relevant, so I just read it since I'm dealing with his evidence. So at page 20, okay, the man, the black man, how was he dressed? I remember he got a t-shirt, it have a name, Ace Clean, Ace Company. And when you saw the Ace, did you know what the Ace of the shirt meant? I will skip all of that and go over to page 21. Line 7, okay, did the man stay there? Yes, for about how long? When they are going until 9 o'clock. 9 o'clock, something. You saw him leave? Yes. And when he left, did Katrina leave with him? No, she stayed. For about how long did she stay after he left? Maybe 5-10 minutes. Did you see?
But we can probably go forward right to page 22, line 18, can't we? Which is the
Yes.
reference to the spread.
I was going there, sir, but I have to tie in this bit of evidence as well, so I didn't want to have to go over it twice.
All right.
For about how long did she stay after he left? Maybe 5-10 minutes. Did you see Katrina leave? Yes. And where were you when you saw Katrina leave? I am in the kitchen. She came to the kitchen to say, okay, see you tomorrow, Mario. And what did you say to her? I said, you coming tomorrow? She said, yes, I'm coming tomorrow because I have plenty to do. I'm so busy. Okay, and when she said she was so busy, what did you understand her to mean by that? 1 second. Mr. Richardson, is it relevant that he thought she meant, what he thought she meant. And the interpreter said at 80, he said he felt something was a little bit strange because he had never seen her work so at night like that.
So that supports the second strange reference, but not the first.
I think Mr. Richardson was saying that the strain was in regards to working late.
No, he said both of them. Mario thought this was strange as she'd never spoken to him that long and all the time.
Oh, Craven Dodgen, sir.
So that one is not made out, the second one is.
Craven Dodgen, sir. Oh, you didn't use the word strange, sir, but at page 16, where he said, the question, when he said, yes, I don't think, yes, when I go to the clean, Katrina's there, she asked me about my daughters, about what I'm working, where I'm working before I work, how many years I am married, something like that, personal things, yes. Before that night, had you ever talked to Katrina about personal things before? I don't remember. Can you remember how long you spoke to her about the personal things, your wife and all of that? The night, yeah, how long? Maybe 20 minutes, 25 minutes. Before that night, had you ever talked to Katrina for that period of time, for 20 minutes? No. So I correct the word strange, sir, but I think it can be inferred from the circumstances of the evidence.
Well, it's all rather nuanced, isn't it? Because what he said at 17 was that he didn't remember ever talking to her about personal things. So that's not about how long he'd talked to her, but the things he talked to her about. So he certainly couldn't remember talking to her about personal things. He then says later down that he'd never talked to her for that period of time, for 20 minutes. He then says that he had, see lines 21 and 22, seen her many times in the evening. So where we get to on that is talk about personal things, don't think so. Talk for 20 minutes, no. See her in the evening many times.
Well, that later, at least when he said strange, see, at page 20. 21. He had never seen her work so at night like that, sir.
Well, then, of course, the vital adjective is missing, but I presume it was a little strange because he'd never seen her work so late at night, or so at night like that. Well, that could be interpreted as meaning he hadn't seen her work so late at night.
Well, so the importance of that, sir, is you will find when one check the record of the swipe card that whilst she was in the building the day before, she actually entered the building twice.
Yeah.
And if he had seen her there, he would have said, yes, I've seen her the day before. In fact, he was never cross-examined on behalf of Miss Burgess. So it was never even suggested to him, but that can't be correct. You saw me there the day before. And in respect of that, the swipe card is Record of Appeal 1, page 126.
Sorry, where are we going?
Just record of appeal one, sir.
Yeah.
Volume 1, page 126. And if you look down, it's on the date is the 2010-2406. At 2022, the cleaner is recorded as entering the building. Katrina Burgess is at 2024 and 2032, which would have been the night before. Which we are saying that leading up to this particular date, some unusual behavior on the part of the defendant or the appellant, Burgess. Moving on, sir, page 8. So Mario left at about 9:30 p.m. Just before I go to I will go to Mr. Bargett and then go to the telephone records. So at 12, Donald Bargett, manager of Lobster Pot Restaurant, said that at about 8 p.m. that same Wednesday, Burgess called the restaurant and indicated that she would be coming over. Excuse me. Between 8:20 and 8:30 p.m., Vernal Keynes was observed at the restaurant's bar. He didn't remember the exact name of the person, but it was all agreed that the person was Vernal Keynes. Bargett spoke with him briefly. When Bargett left for his office at 9 p.m., he left Keynes at the bar having a drink. When Bargett returned to the restaurant at 9:30 p.m., Burgess was at the bar with Keynes eating and drinking. Of course, there is some discrepancy between the cleaner's time. The cleaner said that Keynes, the man, would have left at about 9, and Bargett said that would have seen him earlier in the restaurant. So when Bargett returned to the restaurant at 9:30 p.m., Burgess was at the bar with Keynes eating and drinking. Bargett remarked to her that he thought she had changed her mind in coming over. Burgess indicated that she was waiting on a call from her sister. Keynes suggested that she should call her sister again. From the telephone records, Burgess used her personal cell phone to call her sister at 10:27 p.m. and Burgess and Keynes left the restaurant between 10:45 and 11 p.m. Going to the telephone records now, sir. And that's Record of Appeal, Volume 2. Page 334.
Three, two, 4.
334.
334. Right.
So this is the schedule of all telephone activity on all known telephone numbers used by Katrina Burgess between the 25th of October 2006 and 1500 hours on the 26th of October 2006. You'll notice on the 25th at 18:55:38, which would have been 6:55:38, Vernal Keynes called Miss Burgess.
I'm so sorry. What are we looking at?
Okay, it's at page 334 of the Record of Appeal as well.
Yes.
And the time is 18:55:38. where
Yes.
Vernal Keynes called the work number for Miss Burgess. And apparently they spoke for about 1 minute 45 seconds. Then she made another call to 236-3128. Then she got a call from 1615497212.
We know, can we identify these? Who is the call?
We can't identify who they are. So what the relevant ones is, and you're starting from here for context. And at 19:20:48, which would have been 7:20:48, she called Vernal Keynes.
All right, give me that time again, could you, Mr. Mahoney?
That's 19:20:48.
Well, that seems to be a missed call. That's 2 seconds.
Yes, sir.
Yeah.
And then we seem to have called her back on the next page, 19:20:55. Then on the cell phone, she seems to have accessed the internet for some time.
Where the destination is blank, you say, oh, that's where it says data.
No, call type data, sir.
Yes.
Right.
And then after, excuse me, sir. So the last one was 19:41:15. She accessed the internet I was on the internet 7:56, well, for 7:56 seconds. And then at 7:51:49, she called Marcus Gibbons. Then shortly after that call, she was back on the internet. And then she called her friend Laurie and Kevin Hudson at 7:57:48. Then Vernal Keynes called her at 8:01:02. Then she was back on the internet for a while. And then she called Lobster Pot at...
You say, well, quite a long time.
Yes, sir.
9956.
Well, I'm not sure if that's the time or the
No, that's the duration of that she's been on the.
or the amount of data used. I'm not sure, sir. I have to check back Miss Bell's evidence. She did give an explanation for that, but I have to check exactly what she said those meant.
In any event, the next call is 8 minutes later.
Yes, sir. The next call was to Lobster Pot,
Yeah.
which you'll recall Mr. Burgess said that she called indicating that she was coming over. Then
I don't think 9956 can be seconds because the time
be
between
sort of
21
byte.
and 1.
There'll be some sort of bytes.
I think is yes, sir. I think is
Yeah, I agree because it's too long for the.
Yes.
Yeah.
It only indicates she was on the internet
Right.
using a lot of data.
Yes.
Then over the next page, she called Ronald Burroughs. Based on this, Burroughs said it was around 8, but based on the telephone record, showed that she called him at 9:02:16. And then the call that went to voicemail. And the upshot of all of this, sir, is that
And just the call that went to voicemail, because we've got 33 seconds as the duration of the call here, but I've heard, I mean, we're told that 33 seconds was the duration of the time that the call was on the voicemail. In other words, they said that it was a voicemail message of 33 seconds. So
Well,
that assumes you go straight to voicemail, does it?
well, it would ring and then eventually she gets a message and she have to leave a message, and so it went to voicemail. But it does not necessarily mean that she said anything, because anybody can call anybody and just listening on the phone or even breathe heavy on the phone and then hang up.
Well, most normal people don't hold the phone and breathe heavily for 30 seconds.
If you're not planning on leaving a message and you're transferred to voicemail, you hang up straight away, don't you?
Yes, sir, but it could be the icing on the cake that we're saying that was part of her alibi. Because the critical evidence, the most important call there was the first one to Marcus, not the one he didn't get.
Right.
It's more helpful to your false alibi theory if she left a message, isn't it?
Well, sir, we're unable to confirm or deny, sir. So she got the benefit of the doubt. It was before the jury. But we did not concede that she left a message. But whatever it is in the round, it was part of her setting up her alibi for that night and for that day, that evening.
But you did concede that she told Chief Inspector Cardwell that she left a message.
Yes, sir, and I'm coming to that now because Mr. Richardson, in his submission, seemed to suggest that Mr. Cardwell, and I think these are the words he used, that Mr. Cardwell said, "Come on, man, you lured the man to Derwent Lane," and then she gave her response. That is not so. She gave a witness statement where she was giving her account. She was not being questioned at that time. I think that was also uploaded in the email that was sent this morning. Sir. Yes, it was included.
Sorry, what was included?
Her statement of the 26th of October 2006, when she mentioned the leaving a voicemail message. So it's in one of the attachments that was sent this morning. That was a witness statement.
Right.
Specifically at page.
Now, how did this come before the jury? It was, she didn't give evidence. Plainly wasn't part of the, did the police adduce it as what she told them?
Yeah, the police was cross-examined as to what she told them in her statement. But Mr. Richardson...
Did you put this in evidence via the police officer as being what she had to say on the 26th of October?
No, sir. She was cross-examined, and Mr. Cardwell said that in her witness statement, she did say that.
Yes.
Mr. Richardson, in submission to this court, was suggesting that Mr. Cardwell was putting to her, "Come on, man, you lured the man to Derwent Lane."
Sorry, Mr. Mahoney, are you saying that this full statement was not put in?
It was not put in, sir, but I'm just adjusting it to show that she was not being interviewed when she said this, contrary to what Mr. Richardson had suggested in his submissions to you earlier this week. So put another way, no suggestion was being put to her that she lured anybody to Derwent Lane. She was just giving her account in a witness statement.
We just see the passage in the witness statement which deals with this.
Prevent that, sir. Okay, so it starts at page 5,
Mm-hmm.
the last paragraph, when she's giving an account of her movement. And then over at page 6, six paragraphs down. Before I left my job, I called Marcus again. I did not get any response. I think I called, it was about 9:10. I left a message on his phone telling him I was leaving the office and I hadn't heard from him. I told him I was going to Lobster Pot to get something to eat and then to my dad's and that he can reach me on my cell. So nobody was suggesting anything to her on that occasion when she said that.
So just remind me again how the fact that she'd said this came into evidence.
The police officer, Mr. Cardwell, was cross-examined, and it was put to him that it came that in her witness statement, she did told him that.
I see.
The only parts of it that are in evidence in the case are the parts that were put by Mr. Richardson to the officer, and which
Yes, sir.
And which he confirmed.
That is so, sir.
Yes.
So I'm just seeking to establish the point that she was not being questioned and no suggestion was being put to her at the time when she told the police this.
Right.
But when one look at the evidence, well, let me go to the statement of Mr. Werner Keynes, because this was also evidence before the jury that they also had to consider. And that's one of the attachments in the email sent this morning.
Is this one that was read?
Yes, sir. It's two statements were read into evidence.
Right.
And read as agreed evidence or as disputed evidence?
The judge had to indicate to the jury that the Crown would have liked to have cross-examined him, but he was away at the time.
So what it was read by the defense, was it?
Yes, sir.
Which defendant?
For Burgess.
Thank you.
So his first statement is the first one that you see is not the first statement, sir.
There's one dated the 26th of October.
Yes, that's the first one I'm looking for, sir. Does the court have that one?
Yes.
Yes.
So in regards to that one, sir, he stated that from the first page, my name is Ronald Keynes. I know Katrina Burgess. She's a very close friend. We have known each other at least 10 years. And he also said that strictly platonic. I know that Marcus works at CCS and he's a Trinidadian. I've known Marcus as long as him and Katrina have been together. Met him through Katrina, and I can't remember when and where exactly. Met him more maybe at a club or at a friend's party. Then he went on to say the next page, yesterday, Wednesday, the 25th of October, 2006, I went to see her at her job about 8 p.m. I had a drink at her job while she worked. I had a glass of white wine. Katrina had one too, which she didn't finish. The cleaner was working, he's a Portuguese man. I think he works for himself, I'm not sure. Well, the cleaner said that she wasn't working, she was talking. So she finished work, then we went to Lobster Pot for drinks and dinner. Give and take, we got to Lobster Pot at about 8:30 p.m., give or take. There's some discrepancy there, sir, as indicated between, you would suggest they both left together. Mario and Mr. Burgess would suggest that he went ahead and she joined him after. She had crab legs, as Mr. Burgess said, had seafood crepe and escargot, and had 2 drinks. Katrina had 1 drink. After dinner, we left Lobster Pot, maybe 10 o'clock, 10 p.m., and we went to Flanagan's on Front Street. We drove to Flanagan's in her car, and she drove. We parked up. Now, bearing in mind, the message that was left was to Marcus that, look, I'm going to Lobster Pot to get something to eat, and I'm going to Dad's or her father, Ronald Burroughs. And if they still want to talk, she'll be there. When in fact, she had other plans because she had really told Ronald Burroughs that, look, she's going out to eat, going out with her girlfriend and his friend and his girlfriend, and she'll be coming in late pretty much. And from his perspective, they left Lobster Pot, they went to Flanagan's, and we then left Flanagan. She was tired. I then drove her car and we chilled at my house. We hung out, relaxed, and she went sleep. She slept in my bed, in my bedroom. I slept on the other side of the same bed. I'm not sure, but I'm guessing we left Flanagan's at 11:30 p.m. When I was at my house, I went to sleep also. The plan was to leave my house at 2 in the morning, but I fell asleep. I woke up at 4 a.m. this morning, Thursday, the 26th of October, 2006. I realized what time it was, then I woke her up, then we drove to her father's house. I was the driver, I dropped her off, then I went back home. I dropped her outside of Hunt's Food Supplies at Khyber Pass, Warwick. Her father lives right next door to the house, before Hunt's building on the same side of the road. Then he starts to account for the next day. Going down to the bottom, where he said, I saw her Tuesday as well. That is Tuesday, the 24th of October, 2006. Finished work late, say around 9 p.m. Called Katrina to see what she was up to. She said nothing. The thought was to hang out because she wanted to hang out. And we both decided to go watch movies at my house. I called her from my job, is on both my job telephone and my cell phone. And then it comes down to very good answer. So he accounts for Tuesday night over into the next day. Then over on the next page, page 4, he said my working hours fluctuate. On the average, I work from 7 a.m. to 7 p.m. That's about it. When Katrina came to my house on Tuesday night, she had extra clothes with her. Reading continues, when we ate the food and drinks at Lobster Pot, I paid with my Bank of Bermuda card. That was last night. That day, Katrina was wearing light blue jeans and pretty much confirmed what the cleaner said she was wearing. When we left Hamilton, I drove her car to my house. The plan was to leave my house at 2 a.m., but we left at 4 a.m. and we went back to her car. Then she drove to her father's house, and I drove back home. When I parked the car at Odd Road the night after having dinner, I parked the car at Odd Road Laundromat. Next page, page 5, Katrina told me that her and Marcus have had their ups and downs and that they are separated. She told me they had verbal arguments. That's about all she told me. Last night I was wearing my red Ace polo shirt. So on at the end, when we were at Lobster Pot, I did not have my hat on. I'm trying to find, there's a section where he said that the night when she came over, the night before was the first year that was set at his house. Move on to the second email statement, sir. which is dated the 28th of October, 2006. You said, I'm employed, first paragraph, employed at ACE. My job is meeting room coordinator. I'm a close friend of Katrina Burgess. Stated in my previous statement, I have known Katrina for at least 10 years. Then at the bottom, he talks about Tuesday. And then going over to the second page. In the middle, I did not speak to her until later in the day. This is on the 25th now, which was after 5 p.m. We talked about linking up again that night, and she was also working late. I told her if I finished before her, I would wait around to hear from her, which I did. She contacted me about 7:30 or 7:45 p.m. She said that she was still at work with her boss and that she will be finishing soon. So the plan was to link with Keynes as part of her alibi. And this was, all of this was in play before she called Marcus at 7:51 p.m. Between 7:15 and 7:30, Yes, between 7:15 and 7:30, I went to Lobster Pot with Carlos Pulhoz and had a drink. At 7:45, I don't remember if she called me or emailed me, or maybe she did both. She told me her boss was gone, and I told her I will be there in a little while. And it was our contention that when you look at all of this, this was clearly not the conduct of someone who intended to meet another man, Marcus Gibbons, on that evening at her workplace. Contrary to what she's alleged to have said in the voicemail. I took a bottle of white wine with me to her job, and I arrived there at 8 p.m. I sat off and waited for her to finish work. During that time, I had a cup of white wine, as did she. When she finished work, we left her job and walked to Lobster Pot. At Lobster Pot, we had drinks and dinner, and he repeated what they had. Then next page, page 3, he went into some detail as to when they left, where they went. Then he drove her car to his house, and they apparently took the scenic route from South Shore Road to Codville Road. And remember, this is someone who purportedly left a message for Marcus that, look, if we're still going to meet at my father's house, yet she went out of her way to ensure she didn't reach her father's house until the next morning, 4 a.m. So continuing, I'm trying to find a section where he said that she had never slept at his house before. Okay, at my house, we both were relaxing, and she told me, don't let her stay past 2 a.m. We both fell asleep, and I woke up at 4 a.m. Thursday morning. I woke her up. We left my house, and she drove to her dad's house next to Hunt's store. She turned the car around in Hunt's parking lot, got her stuff out of the trunk, and went inside. I drove her car home, and I went back asleep. This was about 4:30 a.m. Again, part of the alibi. It's her car. Why didn't she drive herself? She drove herself home. So why did he have to come with her, and she handed over the car to him? I'll have to go through this again in the break, sir. But the upstart of this, sir, is that when you look at all the evidence put together, there was no intention from the circumstances of the case, the circumstantial evidence, that she intended to meet Marcus at all, whether it was at Derwent Lane or at her office, based on her plans and movements at the relevant time, there was no intention to meet him at all.
Right. Well, that would be a convenient time to break, I think.
Yes, sir.
We'll
Just
break from.
one thing before we do.
Yeah.
Going back to the telephone records
Yes, sir.
for the 25th of October, we discover when we go into the early hours of the 26th of October that somebody was leaving her text messages at nearly 2 o'clock in the morning, and then ringing the telephone a few minutes after that. Do we know who that is?
No, sir.
Or who the person was with whom she left a voicemail at 4:30 in the morning?
No, sir. But the number would be, I think, a digital number.
Yes. Well, it wasn't in evidence. That's the end of the matter.
No, sir, we don't know who it was, but she was. That's the record, sir. Record speaks for itself, sir.
Um,
And just before I'm just going to say this and stop. The evidence of Miss Card, which I will come back to, said that after the murder, Cleveland Rogers had asked her to call Miss Burgess because Miss Burgess wasn't taking his calls after a while. And Miss Card called Miss Burgess and told her that she used to call Cleveland. She said, yes, she would, and hung up, which would suggest that they had a means of communicating with each other at the time via phone. And that was independent evidence of the connection between the two, contrary to what was suggested by Mr. Richardson and Ms. Mulligan, that there is no evidence that there was any connection between the two. And with that, it's a convenient answer.
Yes, we will adjourn for an hour.
Sorry, I wonder if just before we do, I just wanted to point out in answer to Mr. Justice K's question that the 4 text messages seem to come from an area code 876, so not from a Bermuda number. I don't know if that assists, but that's just an observation.
Right.
Thank you.
Thank you. See you all in an hour's time.
Yep.
Sir.
Thank you, Justice Bell, for hitting the button.
Right.
And I don't see Miss Mulligan. There she is. But none of the prisoners seem to be on the camera. Okay, we have everyone assembled. So, Mr.
Right.
Mahoney.
Yes, Mr. Mahoney.
Yes, sir. Just to go back to that area I was looking for in the statement of Vernal Keynes, his first statement, the 26th of October 2006. And I just want to make a correction. It's the last sentence at the bottom of
The first statement.
2006.
So
His first statement, sir,
yes,
26 October 2006.
yes.
At the bottom, sometimes she also visits my house. She rarely visited my house.
Right, at the bottom of what?
First
Of page 26.
Of the first page?
Yes, sir. Of
What do you mean the bottom of the statement? Yeah. Yes, I see.
Yes, sir. So that was another interesting factor for the jury to consider. Her own witness said that she really visited his house, but on the Tuesday night and the Wednesday night, he was fortunate to have her sleeping there 2 nights in a row, which we're saying was all part of the unusual behavior on the part of Miss Burgess leading up to that particular night.
Yes, I see. Thank you.
Continuing at page 9 of my submission.
Yep.
last paragraph. Ronald Burgess said that on Thursday, the 26th of October 2006, Burgess arrived at his apartment between 4 and 5 a.m. Already went through that. He left her sleeping in the couch when he left for work at 6:30 a.m. On that same Thursday while at work, Burgess called her landlady's lawyer requesting an extension of an extra week to vacate 10 Durant Lane. And I've already pointed out to you that the day before, she told a co-worker of hers that she was moving house on that day, ostensibly to explain the reason why she was so casually attired and going in and out of the office, unusually that day. At noon, Keynes delivered a whole lobster for Burgess's lunch. That evidence was not challenged. Interestingly, Keynes made no reference to that in any of his statements. At about 1:30 p.m., Laurie Hudson visited Seaboard and went into the room with Burgess. This was after the body was found by Marcus Gibbons' co-workers, and news got back to CCS group. Crying was heard coming from the boardroom. However, one co-worker of hers noticed that when Burgess emerged from the boardroom, she emerged with a blank face. She showed no emotion. And
who had noticed that?
Excuse me, sir?
Who had noticed that?
A co-worker. I'm going to find her name. I will ask Miss King to locate the name of that witness.
Okay, thank you.
Mr. Mahoney, I looked into this. Is it the witness Richardson? Sarika Richardson?
Sir. Yes, sir.
She seems to say precisely the opposite. This is at tab 7, page 12. Talks about Katrina Burgess and the lady who came to visit her going into the boardroom. Then bottom of page 12, a few minutes later, a worker came and asked for a tissue because Katrina was crying. That's what I was told, but I did see for myself that she was crying afterwards.
There were two witnesses who spoke to that, sir.
Well, this one has Miss Burgess being the tearful one.
Yes, there's another witness, sir. I'm trying to find her name.
Right.
The one I'm referring to is the one who sat exactly across from the boardroom. I'll ask Miss King to locate the name of that witness, please. I will come back to that, sir.
Right.
Shall I go ahead, sir?
Yes, keep going.
So Vernon Charles said that he attended Marcus's memorial service at St. Teresa's Church on the 2nd of November 2006. Mr. Richardson in his submissions indicated that this was 1 year after. This is not so. It's actually pretty much the following week after the body was found. He arrived early at 3 p.m. while making his way up the steps. Burgess met him on the steps. They hugged, and she told him that she called Marcus to meet him at their apartment. Well, he corrected and said home, but all of that is already before the court, what was said. And she was going to Blue Dragon to get some food, and then she was going to meet Marcus. She then said that two guys came from Trinidad to kill Marcus, Charles, then immediately cut the conversation short. And at the memorial service, Catherine Fisher, a colleague of Marcus Gibbons at the time, said that she was surprised that while she was sobbing, Burgess was not. Then we come to the evidence of Marcus's mother. And this is all part and parcel of the circumstantial evidence, because the jury would have to look at the what was said or done, the behavior of the defendant Burgess or the appellant Burgess before, during, and or after. In respect of the mother of Marcus, at page 10 of my submissions, 19, so paragraph 19. Sandra Ferreira, Marcus's mother, received a call in Trinidad from a detective of the Bermuda Police Service informing her of the death of her son. She said about 2 weeks later, Burgess called her. When asked why she took so long to call, Burgess said that she was traumatized. When asked why, Burgess said that it was a robbery gone bad and that it could have been her because she went to the house 2 days before to get her daughter's uniform, which is interesting, sir, because at the same time, her witness, Miss Wharton, Kendra Wharton, was saying that the week that the daughter stayed with her, that was the week of the murder, school was out. But again, remember our witness, Miss Ruby Landy, was saying that the Wednesday morning, she actually saw Miss Burgess and the daughter heading towards the car. So moving on, Burgess then asked her if Marcus had his wallet on him. Mrs. Ferrari told her that she wouldn't know. Burgess then asked her if the police didn't tell her anything, asked her to get pen and paper, proceeded to give her the name and number of the detective and the number of where she, Burgess, was staying. Burgess told her that when she spoke to the detective, whatever information they gave her, she must call Burgess and give it to her. The conversation ended with Burgess reminding her not to forget that when she spoke to the detective to call her, and Mrs. Ferrari never called Burgess, and Burgess never called her back since, which the jury is entitled to find a bit peculiar, seeing that this is a lady who was living or in a relationship with the Mrs. Ferreira's son for over 6.5 years. And it took her over 2 weeks after the death to call his mother, not so much to inform her of her son's death, but more so to inquire what she knew from the police and to keep in contact with her as to what the police updates her on. So in regards to Ms. Burgess, the evidence of Mr. Vernon Charles, which we said amounts to a admission that the agreement was to meet at Derwent Lane, not the office. And we asked the court to consider all the other bits of circumstantial evidence leading up to that admission as well, in respect of her behavior before, during, and after. On Saturday, the 28th of October, continuing at page 11, number 31. Saturday, 28th of October, 2006, the police executed a search warrant to search Burgess's work area at Seaboard, where she worked. It was discovered inter alia Burgess had her jewelry and watches locked away in her desk drawer, which is a bit peculiar in the light of everything else, of a robbery gone bad that she was trying to assert when she was speaking with Marcus's mother. The employees
I didn't quite follow that. Why was it peculiar? If she thought that there was a robbery had gone bad, she might want to put her jewellery in the office, so there's a robbery that went good, wouldn't find anything.
Yes, sir, but one have to remember that looking at the sequence of events, the jewelry would have been in her desk from before, because when the body was discovered, the police went for her at her workplace on the 26th. And I would have to go to the evidence of Mr. Cardwell to indicate to you the interaction between she and the police up to the 28th. So there is nothing there to indicate that she went to the apartment and took out her stuff after the body was found and took it to the workplace. In any event, the crime scene would have been sealed off.
Did the evidence establish when the jewellery had gone into the desk drawer?
No, sir, but it's part of the circumstantial evidence, sir, that the jury can infer that all of that was done before the night of the 25th of October. From the evidence of Ms. Johnson, the forensic support unit officers, and the Dr. Obafunwo, the apartment was pretty much a crime scene that was close to everybody up until after that day. So she would not have had access to the apartment to remove anything until the crime scene was released.
Well, okay, I'd assume for a moment that she had taken it out of her apartment before the 25th of October.
Yes, sir.
What do you say is the significance of that?
I said, sir, that it's a part putting in place. She was putting in play all the events that would lead up to the 25th, sir. So she absent herself from the property, called the father, the stepfather, to indicate that Marcus is out, so she didn't want to stay there, as if she was afraid to be there. Yet from the evidence, and even from the email, prior to that, she had no problem staying there by herself or with her daughter prior to all of that. But it so happened that from the Sunday thereabout, she sought to remove herself from the property, remove her daughter from the property, although there are indications that they were still living there. And she put herself, sought to create alibis between Monday, Tuesday, Wednesday into Thursday morning.
But you haven't told us what the significance of her removing the jewelry earlier was.
Well, sir, it shows that there's some pre-planning, sir.
Pre-planning of what?
Of what was to come on the night of the 25th.
I'm sorry, I'm obviously being very slow. Why was moving her jewellery out before the 25th of October some form of pre-planning of what was to happen?
The murder of Marcus Gibbons, sir.
I know that, but why was the removal of her jewellery, what part of any plan could the removal of her jewellery have been?
Well, sir, it is, she wouldn't, if the jewelry was there, when the murder went down, she would not be able to have access to her jewelry. Or she could be able to claim that it was a robbery if her jewelry could not be found.
Well, she never did, though, did she? She didn't say to the police, my jewelry's gone.
She didn't, sir, but I'm just indicating this is what was found, sir. It's the evidence in the case. As to why she moved it, I can't say, but there's a lot of unusual behavior that was going on during that time leading up to the 25th.
And for all we know, she might have been keeping her jewellery there for months or years.
That could be so, sir.
Right.
I'm going back to, so then I will next move to Miss. So in a nutshell, so that's the evidence, the circumstantial evidence in regards to Ms. Burgess. And in addition, as well, I pointed out earlier that there was some evidence from Ms. Carr that provided a nexus between both Burgess and Cleveland Rogers. At page 12, my submissions, paragraph 33. Katrina Card was living with her boyfriend, Cleveland Rogers, Burgess's stepbrother, at 9 Crossland Lane. Rogers had introduced Burgess to her as his sister. She said that sometime in 2003, while they were in the vicinity of City Hall, Rogers pointed out Marcus Gibbons as Burgess's boyfriend. Since then, she would see Marcus in passing. That was unchallenged evidence that Rogers knew who Marcus Gibbons was and his connection to his stepsister, Burgess. Card said that on Wednesday, the 25th of October, 2006, she was home and Rogers arrived home at about 6 p.m., went right out. Afterwards, he was wearing a black long sleeve top, black pants with red stripes down the side and a pair of black and red Nike sneakers. He returned home about 9 p.m. and left again about 10 minutes after, similarly attired. At about 5:30 a.m. in the morning of Thursday, the 26th of October, 2006, Rogers came to the sliding door of the apartment. She got out of bed, flicked on the light and said, "Where had you been?" He told her to turn the lights off in a serious tone. She asked him what happened and he responded that nothing happened and she was to turn the light off. She turned the light off. She said that she knew that something happened just by the way he spoke to her. He went into the bathroom and then lay down in the bed. She said that he lay there stiff, just looking up in the ceiling. She placed her hand on his chest and he didn't want her to touch him. She said he was just looking up at the ceiling with his hands by his side as if he was there, but not there. He was spooked. When he returned that morning, he had changed his clothes.
Mr. Mahoney, could I ask you what was the prosecution theory in regard to Mr. Rogers here? Because obviously this paragraph suggests that something had happened between his leaving the apartment at 10 minutes past 9 and his return at 5:30 in the morning. I'm a little puzzled as to what the position was before 10 minutes past 9. What do you say it was?
So, as I said, I can't speculate, sir, because we don't know what time Marcus arrived at the property.
No, but you put together a version of events. So presumably, if these times are correct, the murder happened at some time after 10 past 9.
Yes, sir, but I have to repeat the evidence as is. I have no.
No, but
yes, sir.
well, I understand that, but I would expect that the prosecution would have a theory as to when the murder took place.
Well, it would, I don't know, sir. As I said, if we had an idea as to the time, I could advance a positive theory. What we do know is that Marcus died during the course of that night. And the appellant Rogers confessed that he was the one who did it. As to whether it happened before 9, 10, or after, I'm unable to say because we don't know when he got there.
Except that you were asserting to the jury that it was before the 7 minutes past 9 phone call. Voice.
I wasn't asserting that, sir. I couldn't.
All right.
You know is that she called and she couldn't get him. It went to voicemail. That's all I could say.
I thought we were supposed to infer that he was dead by that time.
Sir, I did not assert that before the jury because I could not say what time he arrived or what time he died. The doctors couldn't help us. None of us could. We had nothing. We had to it's just
Right.
what we had. For me to have said he died before 9 o'clock would be speculating.
Right.
And I would just, on that pause, sir, in answer to my Lord K's question with the co-worker, it was Pinello, Karen Pinello. I don't think her
So what was her name?
Karen Pinello, Pinilla.
Pinello.
Yes, sir.
She hasn't been transcribed, has she?
No, she hasn't.
No, sir, but I'll check to see if she was referenced in the submission.
I mean, before you do that,
Yes, sir.
dealing with that particular incident, this is in the middle of the day after the murder. That's right, isn't it?
Yes, sir.
And the person who visited was Laurie Hudson. So the two people going into the boardroom were Laurie Hudson and Katrina Burgess.
Yes, sir.
And Laurie Hudson was the friend of Burgess.
Yes. I think her best friend at the time, she referred to us.
She didn't work at that place.
No, sir.
And what other connection with the case did she have?
Okay, Laurie Hudson was Katrina Burgess's best friend, and I think Ronald, the stepfather, referred to her as her godmother, because after the body was found, she was staying with Laurie Hudson and her husband in St. George's.
Right.
But Laurie Hudson also was Marcus Gibbons' co-worker. I think she was the chief financial officer or somebody there, but she worked at CCS where Marcus worked. And after the murder, Burgess was staying with Hudson.
Thank you.
At this juncture said, overlooked pointing out a particular photograph to the court that is of some relevance. And it's a photograph of that page 382 of Record of Appeal, Volume 1.
382.
Yes, sir. Sorry. That's Volume 2.
That's volume 2.
So 382 and 383 shows the rear of 3 Durant Lane, which at the time one could have used that area to access, I think it's Border Lane, which was at the back, sir.
Sorry, this is the rear of where?
Excuse me, sir?
The rear of where?
3 Durant Lane, sir.
3 Darmont Lane.
Yes, sir.
Was that in relation to 10 Derwent Lane?
Sorry, not 3, 10 Durant Lane, and my apology. That's where the murder occurred, sir.
Right.
And if one look at the map at page 69, Record of Appeal, Volume 1. So if you look at the inset in the top left-hand corner of the map, that shows the access from the rear of 3 Durrant Lane.
Sorry, Mr. Mahoney, my fault. Could you give me that reference again?
It's on page 69 of Record of Appeal, Volume 1.
Yep. Right, thank you.
Welcome, sir. And the map actually shows the distance from Border Lane North to Crossland Lane, where the appellant Rogers was living at the time. The inset at the top left-hand corner of the map actually shows the yellow arrow actually starts from the rear of 10 Durrant Lane. And there is evidence that at that time, that area that we saw in the photograph that was blocked up more recently was an area that was used by persons to enter and leave the premises by foot. Ruby Landis said that she would use it as well, and they could actually go use the steps next door as well and step over into 10 Durrant Lane. So the relevance of that is to show that this was easy walking distance between where Rogers was living at the time and the scene of the murder. And I think this card said that there are various routes that one could use from Durrant Lane, 10 Durrant Lane, to reach where they were living at the time.
And on a slightly different aspect, Mr. Mahoney, if Marcus Gibbons was driving from Flats or from Ramgoat Hill originally, and he came along North Shore Road, and he would come up Palmetto Road, and he would then take a turn to reach 10 Derwent Lane, would he?
Yes, I would have to. I think if you follow the blue.
He has to go that way.
Yes, if he's driving from the front of the premises, he has to follow the blue, which is to the front of the premises.
Right. I've got it. Thank you.
Yes. If the vehicle was found on Border Lane North, then it would have suggested he parked on Border Lane and used the steps to enter the premises.
Right.
Laurie Hudson presumably did not give evidence.
No, sir. So continuing at paragraph 36, page 13. She said that on Friday, the 27th of October, 2006, this is Katrina Card, while at work at around lunchtime, Card heard on the news that there was a murder. She had a gut feeling. She telephoned Rogers and asked him to tell her that he had nothing to do with it. He told her not to talk like that on the phone and hung up. That evening at about 7 p.m., while they were standing by the stove in their apartment, she asked him to tell her that he had nothing to do with the murder. She said that Rogers' response was, "Yes, I fucking done it." Trina's boyfriend. Trina meaning Burgess. Card said that she subsequently got more detail from Rogers over a period of time. Rogers said that Marcus was cheating on Trina and he hid behind the couch. He didn't tell her how he killed Marcus. He just told her, "I got him from behind." She said that it used to play on his mind As he always used to say, the guy, meaning Marcus, said, "Tell me what I done. What did I do?" Card said that sometimes Rogers used to brag about it and used to say, "Them Boulevard guys don't even know they're hanging around a killer." And whenever they had an argument, Rogers used to say, "I already have blood on my hands, girl." Card said that they used to have a Rambolite knife, and this is where the knife issue came in, along with other decorations on the TV stand in their small studio apartment. The knife was in a green army sleeve, about 9 inches in total. The blade was around 5 to 6 inches and jagged on both sides closer to the tip of the blade. Jagged part of the blade was about 3 to 4 inches, and the part of the blade closer to the handle was like stainless steel smooth. The last time she saw the knife was on the 25th of October 2006. She has not seen it again since that night. At the time of the murder, Rogers was not working and did not have a bank account. Rogers also told her that Burgess was to pay him $5,000 for the murder, and she got to pay him. About a month or two after the murder, they were in their apartment. Rogers went outside for about 10 minutes and returned showing her $500, which he attributed as a part of his payment. Card said that Rogers used to call Burgess for the money. This is what he would tell her. And she stopped answering his phone calls. Sometime after he received the $500 mentioned earlier, Rogers called Card at her job and said, "Trina not answering me. Can you call her and ask her if she has that message for me?" I think message is a Bermudian terminology for money, but Lord Bell may be able to assist you. That is so.
I'm afraid I can't.
Card understood message to mean money. Card said that she called Burgess and said to her, "Clearly trying to get a hold of you." Burgess' response was, "I'll call him later." And that evidence was never challenged, sir. Card said that Rogers told her that he got all the money over time. He was always paid in cash, and she knew this because he showed it. So apart from the confession evidence, as I said, indicated earlier, there is Card also provided additional evidence to connect both appellants as not only siblings, step siblings, but also that they knew how to contact each other. And in fact, on this bit of evidence, well, this bit of evidence established that. At 2 paragraphs down, Card also said that, well, I put in
just a moment. You say that they knew how to contact each other. I mean, most people know how to contact each other. You need a telephone.
Yes,
but the police had conducted an examination of all the telephones attributable to the parties, had they not?
The problem with that, sir, is that Cleveland Rogers didn't come on the radar until many times, well, years after.
Thought he made that statement we were shown in, well, we had sent to us this morning.
Yes, sir, but
Fairly soon.
Sorry, sir.
That wasn't long after the event. It wasn't in the immediate aftermath, but it was.
No, sir, that was about 18 months after, sir.
Yes.
Yes, sir. But the boots were seized but not examined. The evidence against him only came into being when Miss Card gave her statement.
Right.
Much later, I think that was 2018, somewhere thereabouts, sir, 2018, and Miss Foley. So by that time, nobody could remember what his phone number was back then. And in his statement, he didn't give his cell phone number, which I will address shortly because Ms. Mulligan indicated that in her submissions that we couldn't find his statement that he gave to the police, which that is not so because the statement was actually in the record before the court. I think a copy was sent by my colleague. The statement was dated the 13th of March, 2008. That was a witness statement he gave.
So where's that?
The witness statements.
Mhm.
My colleague, Ms. King Dean, sent it today, earlier today, to Mr. Coelho. Ms. King Dean, can you assist as to what time?
Well, I have it. It's an email that came to me at 2:06.
Well, it didn't come to me. I've got an email which came at 2:05 with a whole lot of statements.
And there should be following that, my Lord President.
Yes, it's the next email
Yes.
after that.
Yes, 2 is correct, your time.
Oh, I see. I've got 2:07. Right. Yes, thank you. Got it now.
But I'm not sure what the status of this is evidentially.
Well, it was not before the court, sir, but I brought it to your attention because Ms. Mulligan this morning in her submission was indicating that the warrant couldn't be found, his witness statement to the police couldn't be found, and all of that, which is, the statement part is not true, sir.
Right. I'm sorry, it's probably my fault. I'm still not understanding that. Cleveland Rogers made this statement in March 2008.
Yes, sir.
And he was obviously being asked about his relationship with Katrina Burgess.
Yes, sir.
What does it tell us apart from that?
No, sir. I'm not getting into the content of the statement. I'm just sending it to the court in response to Ms. Mulligan's.
All it tells us is that Miss Mulligan was wrong.
That is so, sir.
Right?
And
yes, sir.
What was she wrong about?
Saying that they hadn't got a copy of the statement of the 13th of March.
Oh, right.
Can I continue, sir?
Yes.
Yes, sir. Thank you, sir.
If there's a pause, you don't have to ask my permission to continue.
Oh, sorry.
Right, there it is.
Yeah, so to answer my Lord Justice K, although Cleveland Rogers came on the radar in 2008, there was nothing there to connect him to the murder. He was just a person of interest at the time. And a witness statement was recorded from him. The warrant search warrant at his house and item seized, and it went dormant from there. Until when Miss Card came forward some years later. So by then, nobody could remember or knew what his cell phone number was at the time. Hence the inability to cross-reference any number with what we have in the telephone record. So continuing at page 15, Card also said that Rogers told her that he buried the evidence up the hills. He never specified what he meant by evidence. She assumed hills meant Friswell Hills, where he had a dog and used to hang out.
Mr. Mahoney, I was surprised by that because it's not Friswell Hills, it's Friswell's Hill, hill in the singular, Friswell's in the plural.
So I'm not too familiar with the place. I'm just going to watch it.
I do know Friswell's Hill.
Well, apparently it's somewhere in the vicinity of where they were living, somewhere nearby there, sir. The distance from Durant Lane to 9 Crosslands Lane would be about 10 minutes by foot, as there are a lot of different ways to get from Crosslands to Durant Lane. Carl also said that sometime in March 2008, while she was at work at the nursery, Rogers called and told her that police came to the house and they took his shoes, asked him questions, and were looking for his brother, Troy. When she went home later that day, she found out that the shoes taken included Rogers' size 9.5 to 10 construction boots. Those are what was referred to as the 5-star boots, which Ms. Johnson made reference to, and I'll come to her evidence shortly. She subsequently found out that the police also took her pair of black Nike sneakers. Carl broke off the relationship with Rogers in 2008 and eventually spoke to a co-worker whose daughter was a police officer in 2015, as she wanted to get what she knew off her chest, and it was the right thing to do. On the 13th of March 2008, the police executed a search warrant at Rogers' residence at Crosslands Lane and seized the 4 pairs of shoes labeled RWC 1 to 4, which included Rogers' construction boots. Just a comment, Ms. Mulligan also made reference to the fact that the boots were tested for DNA and no blood was found. But the boots, one have to bear in mind that this was sometime later, many months, many years later. So the fact that no DNA was found on it was neither here nor there, sir.
I thought DNA stayed there for eternity. Is that wrong?
Not necessarily, sir.
Okay.
Danielle Foley said that she met Rogers in 2013 and was in a relationship with him until 2015. She said that on one occasion in 2014, she was in her bedroom standing by the window and Rogers was laying on her bed with his hands behind his head and he was looking up at the ceiling. Foley was talking in general about the killings in Bermuda. She said Rogers came out and told her that he had killed somebody. There was no facial expression or remorse observed. When she asked him who, he said Marcus Gibbons. When asked why, Rogers said that the guy was stalking his sister and she wanted him to take care of it. Ms. Mulligan made much about the discrepancies and inconsistencies between Ms. Carr's evidence and Ms. Foley's evidence. And as Millard K. rightly pointed out, those were matters for the jury to make a determination on as to what they would accept or reject from either or both. I think that in a nutshell covers the general background, the evidence to the case, and I wish now to go to the specific grounds of appeal.
Yes.
Touch on other areas of the evidence as I go along, sir.
Thank you.
Just one question, sir. The question of severance, I'm not sure that Mr. Richardson, should I go ahead and address it now, sir? Because
yes.
The court had wanted to find out if there was any ruling before.
We still haven't seen Justice Simmons' ruling.
No, we haven't.
My lords, I can indicate that I communicated with the clerk who now serves Justice Simmons, and she's doing her best to locate the ruling for me. She said she hopes to have it for me today.
Would it be convenient, Mr. Mahoney, if you address severance tomorrow in the hope that we might actually have the ruling by close of play today?
She actually said she would liaise with Mr. Coelho. He may have some information, I'm not sure.
The only information that I have is that Ms. Gazard has been asked to transcribe it, and I know that she's received the disc today to start the transcription.
Okay, thank you.
The recording is only between 7 and 10 minutes long, so it shouldn't be a big turnover period.
So is there a prospect of getting, is there a prospect of getting a transcript today?
I would say yes.
Yes. I mean, right.
Yeah, I'm wondering, Mr. Coelho, if you could contact Ms. Gazard and ask if she can give us an estimated time of when we might have it.
Yeah, I can do that.
Thanks for your assistance on that, Mr. Coelho.
That's okay. So, Mr. Mahoney, it looks as if there's a reasonable prospect of getting it today. Would it be convenient, therefore, to leave severance until tomorrow?
Yes, sir. Actually, I was just thinking to just complete the outline of the Crown's case.
Yes, of course.
Yes, sir. So at 17. Professor John Obafunwa, which we'll come back to specifically, forensic pathologist observed multiple bruises, abrasions, incised and stab wounds on the body. He opined that the wounds were essentially disposed around the left side of the body, suggesting that the attacking was from the front and the attacker was right-handed. Some of the wounds were identified as defense wounds. Edges of some wounds were identified as having a serrated appearance, suggesting a blade with...
Mr. Mahoney, what qualifies as a defense wound? What, just something that happened to the victim during the course of him trying to defend himself?
I think that is so, sir. I think it's specifically shown on the hands where there were like several abrasions. I'll go through the photographs shortly as well.
Okay.
Death resulted from severe blood loss with cardiogenic shock due to the stab wound through the lower part of the chest that sliced through the heart. Dr. Obafunwa opined that this wound was inflicted early in the attack and would be enough to incapacitate the victim, with the other major wounds following in rapid succession. Death would have been between 1 and 5 minutes. Based on the depth of 2 stab wounds to the left of the chest, it was opined that length of the blade was between 5.5 to 5.75 inches. The knife had to be one with serrated margins close to the tip. It was possible there could have been a second single-edged blade, but one weapon with serrated edges and straight sides and configuration described was capable of producing the injuries. I'll go more in depth when I'm dealing with that particular ground of appeal. And Janice Johnson, expert in crime scene analysis, blood splatter analysis, and footwear identification analysis, opined that the victim was most likely attacked with forceful impacts at the threshold of the apartment door, and the attack continued inside the apartment and extended back towards the dining area where a struggle occurred with the victim and suspect or suspects. The victim collapsed on the floor doorway leading into the hallway on the bedroom side of the apartment, and the blood splatter was more consistent with the person who attacked the victim at the threshold being inside of the entrance. 3 separate and distinct shoe sole impressions were identified in blood, which included the victim's shoe sole impressions with 2 unidentified shoe sole impressions. RWC3, size 9.5 wide, that's Rogers construction boots, were compared to the documented bloody shoe impressions taken at the crime scene. Based on class characteristics of similar physical size, shape, outsole thread, design, and wear patterns, Rogers construction boots could have created a footwear pattern deposited in blood near the body of the victim. I will just quickly draw the court's attention to the photographs in relation to that. Which is at Record of Appeal, Volume 1, page 83. Page 83, 84. So it starts at 82, sir, in black and white, and then 83 is in color.
So this is a photograph of the tile on which the footprint was made?
Yes, sir. When they, can't remember the chemical that she applied, and it brought up the print. And then 84 and 85 show the left boot of RWC3, and 86, the right boot, RWC3.
These boots are whose?
RWC3 are the boots of Rogers.
So I'm a little puzzled about this. 82 is black and white. 83 is color.
Same, sir.
Sorry?
They're the same. It's just that one is.
Yeah, I know that. But whose boots are these?
Those are the impression in blood that was found at the scene.
Yes, I know that. But I'm not that dense. Were these impressions attributed to any particular person's equipment? Boots?
It was similar, their opinion was it was similar to Rogers at 86. His boots.
Are they saying it was the same boot?
Well,
or just a boot with similar tread?
Yes, sir. The judge ruled that the witness could not say that they are the same, but that they are similar, that they could have been made. They could have made those impressions in blood at the time.
So we see from the photographs of the seized boots that they're size 9 or something. I think I saw that somewhere. Anyway, what I'm going to ask is that whether Miss Johnston, or what she said about the size of the boot that left the footprint.
She said,
I think in the end she gave it quite a large range, didn't she? From something like 7.5 to 11. I can't quite remember the exact evidence.
Yeah.
Yes, sir. But she actually had the prints and the boots, and the jury were able to compare both to see whether they are similar in size or not. The actual print that she had a print on the. And she had an actual photograph of this. So it was tendered in evidence, and it was the jury at the booth where they could put the two beside each other to see if they were similar or what. But the actual boots were in evidence.
But did Ms. Johnson ever say that she thought that the print we see on page 83 was likely caused by the boot we see on page 85?
Pretty much, sir. Actually, a report said they were a match. Submissions were made. The judge ruled that the witness could not say that they were a match, but that they could have been made by the boots. So she had to tailor evidence in accordance with the ruling of the court.
Well, the ruling was quite correct, but that still leaves it open to an expert witness to say whether the findings are strong support or moderately strong support or weak support and so on. Did she express her opinion by a reference to a degree of certitude?
Well, my lord, she was. I could say that she was kept under tight rein, because even in regards to her conclusion on the blood splatter, I was told to put it to her and she would either agree or disagree.
Yeah.
I mean, the problem, and I recognize that I'm in danger of speculating, but if one looks at the image on 83 and compares with the boot at 85, one sees on the boot at 85 that at the top part, there's a great deal of wear, whereas on the picture on 83, there are markings formed on the tile. And if you then go to the top image, which appears to be either the gap between the elevated rubber, and you go immediately to the right, it doesn't look to me as if they match up at all.
They're 2 years older by then.
Sorry?
They're 2 years older by then.
But, sir, as a witness said, I'm trying to find her evidence, the transcript. Okay, I found it, sir. As the witness actually said, sir, in answer to Ms. Mulligan, the boot would not be completely, well, let me find her evidence.
I think that would be helpful, but I take on board my Lord Justice Kay's point.
But sorry, can I be absolutely sure that I'm understanding this? As I have understood it, photograph 82 and 83 are the same, one in black and white and one in color. Is that right?
Yes, sir.
Is 84 different from 82 and 83?
Yes,
or
sir.
the same?
Yes,
Sorry?
sir. 84, let me assist you as to where they were located.
I had assumed that 84 was a slightly blown up version of the heel that we see in 83.
No, sir, that's not it, sir.
I had assumed that, but I thought the assumption might be wrong, and I think Mr. Mahoney is about to tell us it is.
Or if not a blown up version of the same picture, it is a picture of what is or may be an imprint of the same boot.
No, sir, they're different. They
look different to me.
The one with, I can't find a picture of it now, but if you look at page record.
But can I just say, I mean, I think that things are made confusing because as I see it, if this picture at 84 is in fact the enhanced heel, it's turned through 180 degrees compared with the picture at 83, isn't it?
Yeah.
No, sir. 84 is a different print. There were two prints that were found. One closer to the exit, as if the person was walking out of the apartment. That was the one with the heel.
So 84 is a completely different.
Yes, sir.
Right.
But a different what?
And
a different print left on the floor.
Yes, sir. Yes, sir. The enhanced one.
Is anybody saying it's a different shoe?
We're saying that I can't recall which of the boot, but I think her evidence was the pair of boots could have created those prints because they are similar in terms of wear pattern and design. But there was the fuller one, which was 83, was found in the area of where she said the disturbance was, which if one look at page 41, that's Record of Appeal, Volume 1, photograph 41, where there was this area of disturbance.
Mr. Mahoney, it may be that there's not much dispute about this in view of how the evidence came out. If the proposition eventually adopted by Miss Johnson was that the boot at photo 85, retrieved from Rogers, could have left the print at 83, that's about as far as it goes, isn't it?
Yes, sir. I could give you exact words in a transcript. I just wanted to show that the prints were found in separate locations. So at photograph 41, we only see tag 26, but the impression for 23 was found somewhere in that area.
Yeah.
Whereas the one.
Sorry, I mean, this is even more confusing.
Sorry.
It's quite plain that the photograph at 41 is near tab 26 and the photograph at 82 is somewhere else because it's tab 23, and the photograph at 83 obviously has 23 as well. The photograph at 84 has no tab number, and it's not therefore clear whether it is the same as photo 26, tab 26, or somewhere else.
Your indulgence, sir. I'm trying, there were 3 photo albums that were tendered. If one look at photograph 22, sir.
Yes.
Where there is the chair that's toppled over and there is that area of disturbance. I think 23 was found somewhere in that area, sir. And the heel was found closer to the exit of the door of the apartment. I think there may have been another album which had all of those in it, sir.
Well, when you say the heel is nearer the door, do you mean the photo, that which we can see at 84?
Yes, sir.
Because there's a heel at 83.
And it seems to me, Mr. Mahoney, that the heel in 83 and 84 are the same heel, because there is, if you look at 83, there's a line caused by something that's above the boot,
Yes.
the end of the heel, and if one goes to 84, one sees that same line the other way up.
Well, so let's go to the actual evidence, sir. Which,
So just before we do that,
yes, sir.
I remind myself that I think the judge summarized her evidence as saying that the print at marker 23, which is what we see at 83, and the print at marker 26, which we have not identified, but which you say is somewhere in the area of 23, were the 2 prints that she identified as possibly being the boots of Rogers.
Yes, sir.
Is that right?
That is so, sir.
Right.
I still don't know whether you take the view that 83 and 84 show the print of the heel of the same boot.
It's the same boot, sir. I'm trying to remember if she said if it was the left or the right boot.
Right, doesn't matter, but it's the same boot.
It's the same boot, sir.
Yes.
I see that. Right. So what you said before was not right.
I could be in error, sir, in regards to, but
Right.
I know that there were 2 prints there that she was able to compare with the sole of his boots.
Right.
So at page 71 of her evidence,
And so which tab is that?
Tab 14.
Tab 14, sir. Thanks, sir. Actually, we could start at page 70, line 7. And in respect of your analysis of the boots, and you would represent RWC3 represents Balance Man Reebok 5-star brown boot, size 9.5 wide, right and left, which was compared to the documented bloody shoe impressions taken at the crime scenes. That's correct. And RWC3, the brown boots, are included based on class characteristics of physical size and shape, outsole, thread design, and similar wear patterns to the bloody footwear impressions in your original crime scene photographs. That is correct. And the sole design pattern was deposited in blood near the body of the victim, yes? Okay, so in other words, this boot could have created those patterns. That's what you're saying. It could have, yes.
And that's it.
Yes, sir.
That's the evidence.
That was as far as she was able to say, sir.
Yes.
So moving on, sir.
I think it was said somewhere that these boots are one of the most popular in the globe.
Nothing but one have to bear in mind the wear and tear. And they have different designs. So for example, there's a photograph of the boot that was taken from Michelangelo James. At page 79.
We agreed that's a different boot.
Yes, sir. But although they're similar type, the design also is different. There are areas of difference to narrow it down. So for instance, the pattern underneath it, the wear and tear, and shoe size, and so on. So by
Sorry, I'm not clear what you're saying about this. The boot that we see at 7980
yes,
could
sir.
not have left the impressions that we see at 83 and 84. Is that right?
Repeat, sir. I didn't hear what you said.
The boot that we see at
yes,
80 and 81 could not have left the impressions that we see at 83 and 84. Is that right?
That is so, sir.
Yep.
But we are saying that 85 and 86 could have left those impressions.
Could have.
Yes, sir.
The boots, as I've understood it, the boots at 79, 80, and 81 are Angelo James's. Is that right?
Yes, sir. Michelangelo James.
Michelangelo, right. Right.
So I will go quickly through the grounds of appeal in regards to severance.
Well, I think we were going to delay severance until hopefully we have the ruling of the first judge, if that's convenient.
Well, sir, the abuse of process.
I'm so sorry, I didn't hear.
The abuse of process, ground 2, sir.
Yes, yes.
Now, in respect of this particular year, the respondent submits that the learned trial judge did not err in rejecting the appellant's application to stay the proceedings on the basis of abuse of process. There is no presumption that extraneous material had to be available to enable a defendant to test the reliability of the oral testimony of one or more of the prosecution's witnesses. Specifically, Mr. Richardson dealt with the question of the this cell phone, I think, in regards to the voice message that the appellant Burgess said that she left. But one have to apply some context to it, sir. And in the evidence of misplaced correndon, sir, there was evidence that the particular type of phone at the time that Marcus had, sir, there was a particular limit in respect of calls. So the first 10 in were the first 10 out in terms of call record. The relevant witnesses in regards to
that. Does that mean that after the memory has logged 10 voicemails, they go so that the next ones come, or does it just stop receiving voicemails?
Well, I'll go through the evidence of Mrs. Place, but in regards to missed calls and call dial, the evidence of Mr. I think was Mr. Antoine Cannonier was that it was, I think it was limited to 10. So the first 10 calls that comes in, if more calls come in, the first 10 in or the first 10 out.
Let's just take what happens when the 11th call comes in. Does the first one drop off?
The first one drop off. So when Mr. Cabral is going through the phone, he would not, by the time he got the phone and was going through the phone, if the call number 11 came in, he will notice the missed calls from 2 to 11 and not the first one, because the first one would have dropped off. Likewise, dial calls. So he said across the board, it was limited to 10 for calls coming in, calls coming out. And in regards to the voice messages, Mrs. Place gave evidence that there was a limited number on the server. So after it was filled, it would not be accepting more voice messages thereafter. So in a nutshell, so I'm saying that in the context of what happened, the police was not behaving improper in respect to how they handled the exhibit. One should recall that the crime scene was, well, body was found on the 26th. I think the phone was retrieved on the 27th or the 28th. Evidence of Ms. Gibbons, who for some strange reason was reluctant to admit that she was the person who seized the phone. And by the time it reached Mr. Cabral, he would just be checking for the missed calls, which, as I explained before, if there were 11 calls, the first one that came in would be up. So you would see the more recent 10 calls and not necessarily alert him to the fact that there could be one call before. Nevertheless, there was evidence that if he had checked the voicemail, he could have retrieved it. When all is said and done, sir.
So he could have retrieved it even if there'd been 20, 30 calls since.
No, the voicemail. It could have from the handset. That's what the evidence is. Not from, I think, Mr. Cannonier had said that. And Mrs. Place from the company at the time, the server company.
So that if the effort had been made straight away, the voicemail message left by Ms. Burgess could have been retrieved.
In hindsight, hindsight is 2020, sir. But at the time, I think Mr. Cannonier said that he remembered this particular case because this was his cell phone had blood on it, sir.
No, my question was simply whether or not, assuming that Ms. Burgess did indeed leave a voicemail message, that if Mr. Cabral had acted straight away, the voicemail message could have been retrieved, even if there'd been 20 more calls.
It could, sir, based on the evidence of Mr.
Right.
Kemp. However, notwithstanding all of that, sir, there was nothing mischievous or deliberate in respect of the police officer, sir. And nevertheless, the evidence that the witness, Ms. Burgess, sought to have before the court was there before the jury, which, although we did not necessarily agree that she left any particular message, but we couldn't contradict. So in no way was was she prejudiced in any way, sir? So moving on to the application that was made before acting justice, the respondent submits that the learned trial judge did not err in rejecting the appellant's application to stay the proceedings on the basis of abuse of process. I'm at page 23 of my submission. There is no presumption that extraneous material had to be available to enable a defendant to test the reliability of the oral testimony of one or more of the prosecution's witnesses. There is no rule that if material has become unavailable, that it means the trial is unfair, because, for instance, a relevant avenue of inquiry can no longer be explored with the benefit of the missing documents or records. And we say that in any event, the evidence was before the jury. So there can't be any complaint that she was prejudiced.
Right. What evidence was before the jury?
The evidence of that she said that what she told Marcus at 9:07 and left a message saying that she was going to Lobster Pot to get something.
But there's a big difference between the fact that we know only from her police statement that she said that, and the jury knowing it on the basis of somebody having actually heard the voicemail message.
Yes, sir, but we couldn't. It is what it is, sir. It doesn't necessarily mean that she was prejudiced. It wasn't there, yes, sir, but one has to go on to look at what was the effect. Did it undo the prejudice or defense?
Well, the case that is made against you is that the failure to check the voicemail was an abject failure. All you had to do was click on the relevant buttons. You then took the position, well, you couldn't challenge what she had said Yes, the position that you took, the prosecution, was that you didn't accept that any message had been left in the 30 seconds involved, and that the judge in those circumstances should have given a much stronger direction to the effect that in effect, in the absence of the Crown having made any appropriate testing at the time, the jury should proceed upon the basis that that was what she had said. That's the case that is put.
Well, I think the court actually, my submission is based on how the learned trial judge handled it. It was fair to the appellant because we had no basis of challenging what was said. So the jury had to pretty much, in reality, accept that that was what was said. Notwithstanding the fact we cannot say, yes, it was said, or no, it wasn't said. But does that make the trial unfair? We are saying it does not.
Well, if in reality the jury had to accept that that was what was said, it wouldn't make the trial unfair. But the point that is said is that the judge ought to have said, in reality, you have to accept that what she said is what she said.
I don't understand the question.
The judge could have been a great deal stronger in the way that he put matters, and I don't have it at the straight off my head, but we were taken to that part of the summation where the judge dealt with what Chief Inspector Cardwell had said. quickly find it.
Around page 294 onwards of the transcript, of the summing up, I think.
Yes, the passage I was looking for was 295,
Yes.
from line 14 onwards.
In the summation or the transcript, sir?
Transcript of the summation. See, what the judge said, Mr. Mahoney, was he set out what the message was supposed to have been, and then he carries on, if you accept that it was left, that's clear evidence that the meeting was supposed to be at her office. Whether that is an inference that you draw from it or not, of course, is ultimately, once again, a matter for you, which is not quite the same as saying that you have no choice but to accept the veracity of that she did leave a message and that it was to that effect. It's a little hard to say that she wasn't prejudiced by the lack of the voicemail being available, isn't it?
Well, it's my submission, sir, that it's more important as to what was the content of the conversation she had with Marcus Gibbons in the first call, as opposed to a voice message he purported to have left that he never got.
Well, that was obviously Chief Inspector Cardwell's view too.
Excuse me, sir?
That was the view that Chief Inspector Cardwell took.
Yes,
that
sir.
It was the earlier call that was more important.
Yes, sir, because the key thing for the jury to consider was there an agreement to meet at Durrant Lane? As to if there was a change of mind after, it's neither here nor there, because there's no evidence that he got that call. It went to voicemail.
But the message, just assume for a moment that the message was in fact left on Mr. Gibbings' phone and that it was retrieved, that would be inconsistent with the previous, the 751 conversation, would it not?
Not necessarily, sir. It would be part of her alibi, putting together her alibi for that evening. Because
I think that's the point.
Excuse me, sir?
Look at the passage, when you look at the passage at the bottom of page 295, the inference that the judge was talking about was not an inference about whether the message was left or not. It was an inference as to whether the message genuinely reflected what was going through her mind. In other words, because you were contending that if the message is left, that's just part of the false alibi. When he says whether, well, to go back to the previous sentence, if you accept that it was left, it's clear evidence that the meeting was supposed to be at her office. Whether that is an inference that you draw from it or not is ultimately a matter for you. In other words, you can conclude that the message was left in the terms in which she says it was left, but that doesn't mean to say that you are bound to conclude that what it contained reflected what was actually happening.
Yes, sir. But the trial judge can't tell the jury what they are bound to conclude on, sir.
Of course not.
It was really fair in all the circumstances of the case. That was very favorable in to the appellant Burgess.
Was it your express case by that stage of the trial that whilst you couldn't accept that the message was left in the terms that she said it was left, if it was, then that was part of the false alibi? Is that how you were explaining it?
That's how I pitched it, sir, because I was saying that it didn't matter at that point. That's why I indicated that the important point is what was communicated to Marcus Gibbons in the 7:51 p.m. call. That is the key point. Because clearly, and it was our submission that he acted on that, the agreement was confirmed by that call. And as it turned out, he went there from the evidence. He had his own apartment. There was evidence that he left work early on prior occasions to avoid any conflict with Miss Burgess when he was going back to Dorrit Lane to collect stuff. So the question therefore is, why would he choose to go there at night when he had other arrangements with his friends to meet up with them and so forth? So the important call, the important bit of evidence was what was the content of that 7:51 p.m. call. So even assuming that you did send that voice message to him, it mattered not. It's all part of the cover-up and the alibi that was going on throughout that evening into the night to the next morning.
But the 7:51 call left matters on the basis that Mr. Gibbons was going to go to the apartment at 10 Derwent Lane.
That is so, sir.
Right.
So it didn't matter if she called him back at 10 o'clock to say, look, I'm at Vernal Kane's home, come now. Because we're saying the trap was already set.
Yes, I wholly follow that if the evidence is that, as you would put it, the trap was already set, in that it had been arranged that Mr. Gibbons would go to Derwent Lane, then that is consistent with the fact that he'd been persuaded to go there, you say, by Miss Burrows, where the murder was to take place. And on that footing, you would say that the voicemail, if sent, doesn't indicate that there wasn't such a plot, and is more consistent with setting up an alibi's stroke defense. But there is a problem that potentially arises, which is this. It says to the admissibility of the fact that the meeting was to be at 10 Derwent Lane as against Miss Burgess, because what indicates that it was to have been is that he at 7:15 the victim is supposed to tell Scott Lauder that he was going to what was described as the old house, was going to Derwent Lane. That I don't think is evidence against Miss Burgess. And the evidence of 1951 at the end of the day was that Miss Burgess telephoned Marcus, as I'll call him, at the Pierre's house. Pierre says that Miss Burgess said, am I still meeting you? To which Marcus said yes. Well, it's not in dispute that there was said to be a meeting. But then the evidence is that Marcus said to Pierre, yes, that was the beast, and told Mr. Pierre that he was supposed to meet with Miss Burrows at the house that night. Now, the identification of where they were to meet, namely at the house that night, is in evidence which is not admissible against Miss Burrows.
May I respond, sir?
Sorry?
May I respond, sir? I would say that the fact that he went there is evidence. Well, the evidence that he intended, that was evidence of his intention. Fact is that he went there that night with the intention to meet with her. One have to look at all the circumstantial evidence as well. So one cannot just look at that bit by itself, but look at all the circumstances of the case to infer whether or not was it really at her workplace or was it really at 10 Derwent Lane. And also look at her conduct as well, because did she really intend to meet with him at all that night, whether it was Derwent Lane or at her workplace, based on their prior arrangements going on between herself and Vernon Keynes, calling off her father that she's going to Lobster Pot, calling Lobster Pot at 8 after she finished speaking to Marcus Gibbons, and also making pretty much moving along as if she didn't intend to meet anybody else other than Vernon Keynes at her workplace.
Yes, I see. A combination of intent, which is admissible, the fact that Marcus went there suggests that he went there deliberately. Since there was intended to be a meeting, that suggests that the place where the meeting was to be was the place to which he went. And when you add that to the fact that the circumstances that you mentioned indicate that she wasn't going anywhere, it all fits in.
That is so, sir.
That's your case.
Yes, sir. Another point I wish to indicate is after that 9:07 p.m. call, when she said she left this voice message, she never called back. When all his friends heard that he was found dead, were calling, you see his missed calls. When you look at her phone records, she never once tried to call to see, to confirm if that is true. Never called back. So after she left that voice message, that was it. And this is somebody she lived with in an intimate relationship for 6.5 years. So again, as I said, the evidence against her is circumstantial. Individually, the bit of evidence may not mean anything, but one has to look at the cumulative effect of the evidence combined.
And the evidence that of what she said, if the jury accepted it to Vernon Charles at the memorial service, is, you say, an admission.
Yes, sir.
Right?
Yes, sir.
But on any basis, you say, Mr. Mahoney, that since you didn't know until at least sometime midday the following day, it was strange that from 9:07 p.m. on the Wednesday until midday the following day, she'd never made another effort to call him.
No, well, sorry. The body was found the Thursday, sir. And yes, she never made any attempt afterwards.
Yep.
So after that, she never even called to say, what happened? Where were you? I was waiting at work. Nothing.
Right.
There was evidence also led that when his wife came, his wife went to the morgue, I think, when the body was released from the hospital. And it's interesting that she never turned up. So that's another part of the circumstantial evidence case where she was living with this man. He just moved out a week or two before and nothing. He died. She never even attempted to even go to the morgue based on the evidence that was there. No tears at the funeral. And that wasn't challenged.
Right.
So in going back to the actual appeal, well, the ground that the judge was wrong in not acceding to the abuse of process application. And it's our submission that the learned judge did not err in his ruling. And the case I'm relying on is the case of PR and the Queen. (2019) EWCA CRIM 1225, which dealt with the issue of whether the trial judge was right to allow the case to proceed when evidence gathered by the police in 2002. And we would say in this instance where there was an omission by the police to gather evidence relevant to the appellant's offense was destroyed by, well, in that case, water or damage and unavailable for the trial in 2018. We say that the principle is equally applicable where by inadvertence, the evidence that relevant to the appellant's defense was unavailable sometime later in a trial that occurred almost 13 years after, sir. And Law Justice Fulford reviewed the relevant law. I'm at page 23, sir.
Mm-hmm.
Paragraph 65, it is important to have in mind the wide variations in the evidence relied on in support of prosecutions. No two trials are the same, and the type, quantity, and quality of the evidence differs greatly between cases. Fairness does not require a minimum number of witnesses to be called, nor is it necessary for documentary, expert, or forensic evidence to be available against which the credibility and reliability of the prosecution witnesses can be evaluated. Some cases involve consideration of a vast amount of documentation or expert forensic evidence, whilst in others, the jury is essentially asked to decide between the oral testimony of two or more witnesses, often simply the complainant and the accused. Furthermore, there is no rule that if material has become unavailable, that of itself means the trial is unfair, because, for instance, a relevant avenue of inquiry can no longer be explored with the benefit of the missing documents or records. It follows that there is no presumption that extraneous material must be available to enable the defendant to test the reliability of the oral testimony of one or more of the prosecution's witnesses. In some instances, this opportunity exists. In others, it does not. It is to be regretted if relevant records become unavailable. But when this happens, the effect may be to put the defendant closer to the position of many accused whose trial turns on a decision by the jury as to whether they are sure of the oral evidence of the prosecution witness or witnesses.
I wonder if we can shorten this, because I'm sure we've all read this. In
Yes,
effect, the learned law justice says that whether you can receive a fair trial depends on the circumstances. That's paragraph 66. It may be that a fair trial is unachievable when relevant material can't be deployed. The circumstances, paragraph 67, the circumstances in which the court will be able to conclude that is so will be likely to be few and far between. There are often holes in the prosecution case which cause problems for the prosecution. Then at 68, if you want to stay, you must make good to the civil standard that owing to the missing evidence, you'll suffer serious prejudice to the extent that no fair trial can be held, although see the last sentence it may be different, where evidence has gone missing through some serious culpability or bad faith. And then it's relevant to consider the precise nature of the relevant questions when evidence is missing. Then if we go to page 27, paragraph 71, imposing a stay is not a step that will be taken lightly, but will only occur when the process is unable adequately to deal with the prejudice caused to the defence. That's what it amounts to.
Yes, thank you, sir. And just to close off, I think these are pretty much, I have my submissions on this ground at paragraph 11.
Yes.
Respondent submits that the appellant's evidence was put before the jury via the evidence of Chief Inspector Cardwell. The respondent was not in a position to challenge that evidence. The 9:07 p.m. call had to be viewed in relation to all the other evidence in the case. He submitted that what was said in the call at 7:51 p.m. to Marcus, having regard to all the circumstances of this case, was of more importance than the purported voice message at 9:07 p.m. The respondent never considered the mere fact that the call went to voicemail meant that a message was left. I think this was in response to a submission in the appellant Burgess's written submissions. The defendant herself could have given evidence of the message she allegedly left if Chief Inspector Cardwell's evidence of what the appellant told him was in dispute. She did not. The evidence of Chief Inspector Cardwell, DC Iris, Anton Cannonier, Place, and Kevin Cabral, well, those transcripts are known in before the court. I won't waste time to go through them. Yet the relevant, well, skipping from there, sir. So as I was saying earlier, sir, at Mr. Cannonier gave evidence that the storage of missed, dialed, and received calls on the instrument was limited to 10 per category. The phone instrument itself would keep a record of the most recent 10 calls per activity. The first call in is the first call pushed off the record. There was also evidence that many persons tried calling Marcus from the night of the 26th of October 2006. Accordingly, when PC Cabral examined the instrument on the 1st of November 2006, he would be making a note of the 10 most current missed calls and dial call, etc. Chief Inspector Cardwell indicated that he was able to verify that the appellant did go to lab support, as she had said. Respondent submits that the summation of the trial judge, particularly in relation to this issue, should be taken as a whole. The summation taken as a whole and its cumulative effect was fair, balanced, and appropriate. All the circumstances of this case, there is no miscarriage of justice or abuse of the process of the courts.
I'm sorry, just to, before we finish this ground, paragraph 13 deals with missed calls. What we're actually concerned with in the present case is voicemails.
Yes.
Yes, sir.
And I had previously understood that the voicemails were subject to the first 10 in, first 10 out principle. But I think you said to Justice Bell a moment ago that that wasn't so.
No, I think, sir.
But if it isn't so, we'd be able to find the voicemails now.
No, sir. Well, no, couldn't find it now, sir. There's a server. The evidence and Keisha Place's evidence, sir, which was that was produced last week.
Sorry, whose evidence?
And Keisha Place.
Where do I find that?
That's tab 2 of the third transcript bundle.
Oh. Yes.
Evidence.
I'm sorry, my.
I don't think this particular transcript has a volume number.
My third volume, rather unhelpfully, is simply a completely unnecessary repeat of the arraignments, rulings, and summation by the court.
There's an additional bundle that says on the front, transcript as per order of the 11th of May.
Yes. And that's what,
volume 3.
Yes.
Actually, in the learned trial judge, I think he summarized it in the summation. But just to explain that point, sir.
Line 17.
Page 7, line 17, sir. And Keisha, please, sir.
yes.
Start at line 4. Okay, in respect of voice recordings, was there any particular platform that would deal with that? Yes, well, in 2006, I believe the platform was called Starfire. And how did that work in regards to voice messages coming in? What do you mean? In other words, okay, now, in terms of storage, okay, was there a limitation on the storage capacity? Yes, there was a limitation. Depending on the device, the amount of messages that could be held would be 7 to 10. Yes. The system was used for all of our subscribers, so the capacity of it at the time, once it reached the capacity, it would purge individuals' messages. And when you say purge individual messages, what do you mean? The system would automatically delete these messages to provide more space for new messages. Okay, just for clarity, so depending on the instrument, it would be, you say 10 to 12, 7 to 10. 7 to 10, sorry, yes. And just for clarity, let's say I just want to get an understanding what you mean by purge and the capacity. Let's say that the capacity was probably 10, and 12 voice messages come in. Assist us in understanding how the purging will work. When I say purge, I mean for all subscribers, so it wouldn't be one individual's phone, right? But if that individual had a message that was there for an extended period of time, the system would delete it to make more room for all the other messages that are coming through for all subscribers, not just an individual. Okay. So it's across the board. It's across the board, yeah. Okay, so what I want to find out is for an individual subscriber across the board, for an individual subscriber, the limit was 7 to 10. Back then, yes. In this case, yes. Okay, I want to know if you go over the number, it wouldn't let you. What's that? It would not let you go over the number. Okay, so you couldn't go over the number? No. And all right, so what would happen if the person is at their maximum and another person called? It would tell you their voicemail box was full. Okay, and you could not leave a message. Okay, all right. And then we took the break. So I think the message were kept for a particular period of time. And then afterwards, the server, which was I think it was kept in the Cayman Islands at the time, would purge it. But then in cross...
But Mr. Mahoney, the point surely is not that the voicemail message would have been purged from the phone. It might well have that if the inquiry was made from the cell phone company, then it could be retrieved if it had been made quickly. Is that not the case?
That is the case, sir, but I was answering my Lord Clark, who was asking if the voice message could probably still be in existence now.
So the answer is that it's probably gone, and it's certainly gone if there are 10 more calls.
Yes, sir, it would have been, well, after all this time, would definitely have been purged by now.
But to my mind, the more informative piece of evidence was that, for instance, if you go to 22 line 5, Mr. Richardson says, let me ask you this, would your company have been able to retrieve a voicemail if they'd actually brought you the phone? Answer, yes, sir.
Yes, sir.
Right.
I'm not sure if the police were aware that that could have been done, because she said it was never taken to her before.
Right.
Right.
But we're still back to the same point, sir, that even if she did leave the message that she said that she left, our submission is that in the looking at all the circumstances of the case, the important aspect of it is what did she communicate to Marcus when they made that agreement, and not what happened after he left in pursuance of that arrangement.
Hmm.
Brilliant answer?
Yes, I think we might have a short break for 10 minutes now.
Sir.
Right. Are we all? I think we're all assembled, aren't we?
Yes, sir.
Right.
I'm moving on to, there's no further assistance I can give in regards to ground 2. I would like to go on to ground 3 for Burgess, ground 2 for Rogers. No case to answer.
Yes.
So paragraph 15 of the respondent submission. The respondent submits that the trial judge cannot be faulted in ruling that each appellant had a case to answer, having regard to all the circumstances of this case. The respondent further submits that the cumulative effect of the summation as read as a whole was fair, balanced, and appropriate. And at the end of the summation, the appellants raised no concerns when asked by the trial judge if there was any concerns with the summation. And I included that, I noticed that Mr. Richardson did say that, raise a point in regards to summation at page 77, paragraph 14.
Of the summation.
Yes, sir.
I don't think you mean the summation. You mean his submissions?
No, from my note, I have summation page 77, line 14. I think,
Sorry. 77 line
it's,
14.
yes, sir, I think all of this was more in relation to the new ground 9A, I think, where he was, I think in effect, he's saying that the court should have left alternatives, I think.
I'm sorry, what are we supposed to be looking at?
We're supposed to be looking at ground 3, no case to answer, but I know.
No, I know that, but which is the, you said page 77.
Oh, page 77 of the summation, line 14.
Yes.
And I was just adding that on reflection, I think these submissions, some of what my learned friend said, may have been more akin to the ground of appeal, the additional ground of appeal, ground 9A. But I will read it since we're here, where the trial judge said, again, I do not think in this case there is any issue taken by the defense, either Mr. Rogers or Ms. Burgess, that the person who stabbed Marcus Gibbons caused the injuries you have heard described had any other intention in mind but to kill Marcus Gibbons. So again, that should not, I think, cause you any difficulty.
What's your point? That Mr. Richardson didn't complain about it?
Well, my point is, sir, that, and I will address it more directly when I'm dealing with ground 9A, the new ground of appeal, is that there was no complaint actually raised, and this was what we are all agreed on. Before we addressed the jury, sir, the learned trial judge invited parties to document what they say their cases were. And in the email that was sent this morning, was included in the attachments there, the case for the appellants Burgess and Rogers, but more specifically dealing with the point of no case to answer. I would like to draw the court's attention to the case of DPP and Varlock. This was sent this morning to Mr. Quilla. It's in the
So this isn't in our bundle of authorities.
Mr. Quilla, was it included in the cloud?
Yes, but I can bring it up. Just give me a sec.
Makes one wonder, Mr. Mahoney, what we'll go back to when we actually have live hearings.
That's interesting, sir. I often wonder about it myself.
Hard copies.
So the case is DP, Director of Public Prosecutions, and Varlock, British Virgin Islands,
Yes.
Kingdom Privy Council, 2008, 56. And in a nutshell, I'll just read the paragraph 3.
But I think if Mr. Coelho is going to put it up on our screens, it would be helpful to wait until we can see it, I think. Thank you.
At paragraph 3, sir. Sorry, paragraph 4. The prosecution case against the respondent was that she was used as a lure to get Todman to go to a meeting place on the mountain road where he was to be murdered. It was based largely on evidence of telephone calls made between the defendants, from which the prosecution sought to draw the inference that she knew and agreed to the plan to kill Todman. It was claimed that she was instrumental in getting him to travel into the mountains and tipped Ham off by telephone when he left her apartment for the meeting. I acknowledge that the circumstances of this case in the authority is different from this one, but the point is that the fact that one can be guilty of the offense of murder, premeditated murder, even if their role is to lure the victim to the place where they are to be killed. Paragraph 13. There was no evidence that the respondent was present when Todman was killed. The case against her was that she was part of the joint enterprise to which the other 3 defendants were parties, that he would be lured to the meeting place where it was contemplated that he would or might be killed. This was evidence the prosecution argued by the pattern of the telephone calls allied to her behavior after the murder. It was submitted that the evidence was sufficient to establish that she knew of the plan for a meeting between Todman and one or more of the respondents' co-defendants, and further, that she knew and accepted that a possibly lethal attack might be mounted on him there. The defense case was in summary that even if it might be inferred from the evidence that the respondent knew that Todman was to meet Ham, it could not be established that she knew the true purpose of the meeting. That meeting, it was argued, had been connected with some transactions such as drug dealing, and it was a step too far to infer that it might involve a lethal attack on Todman. Submissions of no case were made to the trial judge at the end of the prosecution evidence on behalf of each defendant, and their counsel applied to the judge to have the case against their clients withdrawn from the jury. The judge gave a reserved judgment in writing in which she acceded to the application in respect of the murder charge against Pemberton, but rejected all the other defense submissions. At the outset, she set out the governing principle in determining applications of no case based on the Queen and Galbraith and Labrador and the Queen, BVI Criminal Appeal number 10 of 2001. The essential statement of the law for present purposes is a sentence from the judgment of Lord Lane's Chief Justice in Galbraith at page 1042. And we're all familiar with that, sir. I'll move on. Has long been regarded as a canonical statement of the law and was so accepted by both parties to the appeal before the judge. And the judge reviewed the prosecution evidence and stated her conclusions in respect of each defendant. Moving forward to go through the judge analysis of the evidence in that case. And moving over to paragraph 21. The basic rule in deciding on a submission of no case at the end of the evidence adduced by the prosecution is that the judge should not withdraw the case if a reasonable jury properly directed could on that evidence find the charge in question proved beyond reasonable doubt. The canonical statement of the law as quoted above is to be found in the judgment of Lord Lane CJ in the Queen and Galbraith. That decision concerned the weight which could properly be attached to testimony relied upon by the Crown as implicating the defendant. But the underlying principle that the assessment of the strength of the evidence should be left to the jury rather than being undertaken by the judge is equally applicable in cases such as the present concerned with the drawing of inferences. The principle was summarized in such a case in the judgment of King CJ in the Supreme Court of South Australia in questions of law reserved on acquittal number 2 of 1993, 61 SAS R15 in a passage which their lordships regard as an accurate statement of the law. It follows from the principles as formulated in Billick Super in connection with circumstantial cases that it is not the function of the judge in considering a submission of no case to choose between inferences which are reasonably open to the jury. He must decide upon the basis that the jury will draw such of the inferences which are reasonably open as are most favorable to the prosecution. It is not his concern that any verdict of guilty might be set aside by the Court of Criminal Appeal as unsafe. Neither is it any part of his function to decide whether any possible hypotheses consistent with innocence are reasonably open on the evidence. He is concerned only with whether a reasonable mind could reach a conclusion of guilty beyond reasonable doubt and therefore exclude any compelling hypotheses as not reasonably open on the evidence. I would restate the principles in summary form as follows. This direct evidence which is capable of proving the charge, there is a case to answer no matter how weak or tenuous the judge may consider such evidence to be. If the case depends upon circumstantial evidence and that evidence, if accepted, is capable of producing in a reasonable mind a conclusion of guilt beyond reasonable doubt, and thus is capable of causing a reasonable mind to exclude any competing hypotheses as unreasonable, there is a case to answer. There is no case to answer only if the evidence is not capable in law of supporting a conviction. In a circumstantial case, that implies that even if all the evidence for the prosecution were accepted, on all inferences most favorable to the prosecution, which are reasonably open, were drawn, a reasonable mind could not reach a conclusion of guilt beyond reasonable doubt, or to put it another way, could not exclude all hypotheses consistent with innocence as not reasonably open on the evidence. A similar statement appears in a recent judgment of the English Court of Appeal Criminal Division in the Queen and Jabba 2006 EWCA Crim 2694, where Lord Justice Moses said at paragraph 21, the correct approach is to ask whether a reasonable jury properly directed would be entitled to draw an adverse inference. To draw an adverse inference from a combination of factual circumstances necessarily does involve the rejection of all realistic possibilities consistent with innocence. But that is not the same as saying that anyone considering those circumstances would be bound to reach the same conclusion. That is not an appropriate test for a judge to apply on the submission of no case. The correct test is a conventional test of what a reasonable jury would be entitled to conclude. CF the Queen and Von Bockham, unreported, 2000 WCA Crim, paragraph 32.
I don't think you need read out the cases and the numbers because we can
Yes,
see
sir.
that. Thank you.
So the judge held that the evidence was such that a reasonable jury might convict. The Court of Appeal held on the other hand that because it was in their view as likely that the respondent was a party only to a purpose which did not involve contemplation of the killing of Todman, there was no basis for speculation on which to ascribe to Viola participation in one as opposed to the other. They did not apply the test of determining what inferences a reasonable jury properly directed might draw, as distinct from those which they themselves thought could or could not be drawn. Their lordships considered the Court of Appeal were in error in this respect. The trial judge correctly approached the submission of no case by reference to the test whether a reasonable jury properly directed might on one view of the evidence convict. When one applies this principle, it follows that the fact that another view consistent with innocence could possibly be held does not mean that the case should be withdrawn from the jury. The judge was, in their lordship's opinion, justified in concluding that a reasonable jury might, on one view of the evidence, find the case proved beyond reasonable doubt and convict the respondent. They were clearly entitled to draw the inference that the respondent telephoned Ham in order to inform him that Todman had set out along the mountain road. In determining whether this was with knowledge that he might meet with lethal force at the rendezvous, they were entitled to place in the scale the antecedent and subsequent facts. They could also have regard to a number of possible significant facts. And I won't bother going through all of that since it relates to that particular case. So the upshot of this case, my lord, was that the decision of the Court of Appeal was overturned and the conviction was restored. And we submit that in this case at bar, the learned trial judge cannot be criticized or faulted in his approach to the no case applications by both appellants and ruling that they both had a case to answer.
Are you finished with this authority, Mr. Mahoney?
Yes, I'm finished.
Yes.
And I will leave off the court. I could move on to, I think it's ground 5.
Yes, just before we go to ground 5, what I think is said, and I'm probably summarizing it rather inadequately, is that there were a number of possibilities that putting it at its highest, there were a number of possibilities that the jury could conclude. One was that there was no plan to, Miss Burgess was not party to any plan to lure the victim to the apartment. The other was that there was a plan, but that it was simply to have a discussion, and things got worse and he was in fact murdered. And the third, that there was a plan to punish him but not kill him. And that given that there were all these possibilities, and given the circumstantial nature of the case against Miss Burgess, it was incumbent on the judge to go through with the jury, the possible conclusions that they could reach, not simply whether they did or did not reach the conclusion that the prosecution asserted, and to do so, this is getting onto the 9A point effectively, by reference to the evidence that was admissible against her alone. I mean, you may want to deal with all that under 9A.
Yes, sir. That's why I was dealing with the no case to answer ground, which is from 9A, which deals with the summation itself.
Yes. Right, so you've said what you have to say about the summation.
Yes, I would ask if I could deal with 9A tomorrow, because
yes,
I emailed
yes,
5 minutes
yes,
tonight. I've not had an opportunity to properly.
Yes.
Whereas,
before the court adjourns, if Mr. Mahoney is finished then, is that right? I do have an issue I need to raise with the court, if that's possible.
I'm not finished.
Oh, I apologize. I thought you were done for today.
No.
My apologies. I will wait.
And in respect of Cleveland Rogers, there was sufficient evidence for the jury to make a determination, notwithstanding what Ms. Mulligan was indicating as inconsistencies and discrepancies. Those are matters that were properly left for the jury to make a determination on as to what they would accept, reject, and what weight to attach.
Yes, just before we leave Mr. Rogers, there are a number of discrepancies in the evidence. But one potential discrepancy, which I think we might like some assistance on, is this. Mr. Rogers is said to have come home at 6, to have or to have left at 6 with black Nike shoes and come back again at 9, still wearing the black Nike shoes and the same outfit that he'd left the house in previously, without any sign of blood, toil, tears, or sweat. In other words, he can't have been wearing. Sorry, and that was on that account. He came back apparently in exactly the same condition as he left, and without the boots the prosecution suggested, the construction boots, which were his boots, which the prosecution suggested had left their footprints at the scene of the crime. What do you say about that?
Well, sir, in regards to that, sir, it is open for the jury to accept a part of what the witness says or not. Bearing in mind the direction is given that a witness, their recollection may be faulty, or in the circumstances of the case, he did leave. It's always open for him to have had the boot somewhere else at the time. We don't know, sir. But as it turned out, they may even reject her evidence on that. But if they accept her evidence, which clearly they did, that he confessed to killing him. So even if they reject the supporting evidence as no support of the, let's say the shoe print, the boots, and so on, if they accepted her evidence that he confessed to her, that by itself is sufficient for the conviction to stand, sir. But one also have to remember that we don't know at what part of the time period he was killed. Was it before 9 or was it after 9? We can't say.
Well, I think what you're saying is we don't know when he was killed, but if he was killed before 9, Miss Card, who said that he confessed, was right about that, but may not have been right in recollecting that he left and came back with sneakers and didn't appear to have any blood on him. Or alternatively, he left at 6 and came back at 9 and left it again with sneakers in each case, but the murder in fact took place after 9 o'clock, and at some stage between 9 and 5, he changed into boots.
That is so, sir.
Right. Okay. Right. Thank you. Next item.
I think Miss Mulligan wanted to, well, may I inquire for at what time we break, sir?
Well, I thought we might, if we can, do another 15 or 20 minutes, if that's convenient. How are we off for time? I mean, tomorrow is our last substantive day.
I think we may still have to come back to pursue the jury matter, sir.
Yes, but leaving that aside.
Very well, sir.
Sorry, are you going to answer my question?
Oh, sir, I'm just looking at offer there.
Oh, I see, right.
That's what I'm looking at, sir. I would say another 2 hours, sir.
Another
2 hours.
2 hours.
Yes.
So we are leaving aside the jury question. We're going to finish tomorrow, are we?
Well, there's a severance point we have to come back to, so.
I know that.
Very well, sir.
We should probably have the severance judgment this afternoon. It's only 7 minutes long.
Very well.
Well, we better keep on for a bit, Mr. Mahoney.
Very well. In respect of the Ground 5, sir, I think is hearsay evidence.
Yeah.
Yes. Paragraph 16, the respondent submits that this ground also lacks merit, where the admission of evidence which was admissible against one defendant but not against his co-defendant resulted in real risk of prejudice to the co-defendant. The judge should ensure that the interests of the co-defendant were protected by explicit directions to the jury to the effect that the statement of one co-defendant was not evidence against the other. In any event, no application was made to exclude such evidence, which I should say redact such evidence, which would have certainly failed. And the judge had given the jury emphatic and repeated directions that the co-accused statement was irrelevant to the case against the appellant. And the authority of that is the Queen and Hater, which I will go through at depth when I'm dealing with the severance point, and and the Queen. I should indicate, sir, that throughout the trial, when Ms. Card gave her evidence, the judge did give a direction to the jury to the effect that the evidence that she gave in respect of the confession was evidence against Rogers only and not Ms. Burgess. Also, after Ms. Foley gave her evidence, yes, after Ms. Foley gave her evidence, just after the witness Steve gave his evidence, the jury was also reminded that in respect of the evidence of both Card and Foley, with the admission, the evidence was against Rogers and not the appellant Burgess.
So he said that, what, before or after Card and Foley had each given evidence?
He said that after Card gave her evidence and after Foley gave her evidence.
Yeah.
There was a witness that came immediately after Foley named Steed. I can't remember his first name, but after his evidence, he took that opportunity to remind the jury. And throughout the summation itself,
yeah,
he on numerous occasions reminded the jury that the evidence of Card and Foley in respect of the purported admissions were evidence against Rogers only, not Miss Burgess. Other cases, Labon and the Queen, sir. Which is the citation is 1995 to All England Report 602 at page 613H. Inevitably, the legal principles, as your lordships have stated them, result in a real risk of prejudice to co-defendants in joint trials, where evidence is admitted which is admissible against one defendant, but not against the other defendants. One remedy is for co-accused to apply for a separate trial. The judge has a discretion to order a separate trial. The practice is generally to order joint trials. But your lordships observe that ultimately the governing test is always the interest of justice in the particular circumstances of each case. If a separate trial is not ordered, the interests of the implicated co-defendant must be protected by the most explicit directions by the trial judge to the effect that the statement of one co-defendant is not evidence against the other, and that duty the trial judge fulfilled in the present case by emphatic and repeated directions that the last paragraph of Russell's statement was irrelevant to the case against Labon. The judge could not have been more explicit. For all these reasons, the ground of appeal under consideration is rejected. And I go now to the case of Hater, which is just the head note I will go to, sir. And Hater is 2005, One Weekly Law Report, 8605. Current sir. So I don't have my marked copy here. Here was a case, sir, in which I look at the head note, sir. The defendant and two others, R and B, were indicted on a count of murder. All three were tried jointly. The Crown alleged that R had been the killer, that B had procured the murder, and that the defendant had acted as the middleman. It was common ground that should the case against either R or B fail, the case against the defendant would also fail. Case against R was based entirely on admissions made by him out of court and in the absence of the defendant. At trial, the Crown did not use R's admissions to confront any part of the defendant's defense. At the close of the Crown's case, the defendant submitted that there was no case for him to answer on the ground that since R could only be convicted on the basis of his out-of-court admissions, there was no evidence admissible as against the defendant that R was the killer, and accordingly, the case against him was bound to fail. The judge rejected that submission, and in his submission, summing up, directed the jury that if they were satisfied on the evidence admissible against R, that R was the killer, then the established fact was available to them in considering the case against the defendant, but that they should take care not to allow anything in R's admissions to play any part in their consideration of the defendant's case. B and R and the defendant were convicted. The Court of Appeal dismissed the defendant's appeal and upheld the trial judge's ruling and directions to the jury. This case deals with another point that we will come back to, sir, but this is also an example where the fact that you have a co-defendant in which their confession evidence is against him does not make the case unfair to their co-defendant, sir. Once proper directions are given to the jury that the confession evidence is evidence against that defendant. So this is another illustration of the principle in application, sir.
Yeah.
Unless any further question on that ground, those are my submissions on ground 5, sir. Sorry.
I don't think so.
Yes, ground 5 for Burgess.
Right. Yes. Well, I suspect that that would be a convenient moment to adjourn. Just before we do so, can you tell me or remind me whether there was any evidence as to the condition, either as to clothes or footwear, in which Rogers returned at 5 o'clock in the morning after what is said to have been the murder?
She could not recall, sir. She said that she remembered he came back in different clothes, but she can't recall what it was. She said that Miss Carr, she said that since the 25th, she has not seen the tracksuit nor the Nike ever again.
Sorry, since the 26th, she's not seen the...
Since the 25th, when he left in the 20th, on the 25th with the Nike sweatsuit and the sneakers, she hasn't seen those again. She said he came back in different clothing on the morning of the 26th, but she can't recall what it was.
I see. So he came back in different clothes. She hadn't seen the original ones again. Had she any recollection of the footwear in which he came back?
No, sir.
Or whether it was different from the footwear which he wore when he left?
I don't think she could assist. All she could say was that I think the implication was that he came back in different footwear since she hadn't seen the Nike again after the night of the 25th.
Yes, I see. Yeah. Right. Well, Ms. Mulligan, is it something you wish to raise now, or?
Well, it's a matter of scheduling tomorrow. Apparently, this morning, an order was made that I'm to appear in the Supreme Court tomorrow morning before Mrs. Justice Simmons. And the orders that I'm to appear prior to 12:30 and appear in person. I don't think that's likely to be possible given our schedule and given that there might be some reply or some other matters for us to deal with, even if Mr. Mahoney is correct on the 2-hour estimate. So I'm not sure how I should handle that. It is an order that I must appear in person.
Well, do you know what it's about?
Yes, a client of mine who was sentenced some time ago has been arrested on a warrant in relation to a breach of probation, a failure to attend court. Mrs. Justice Simmons has ordered that I attend to bring an application to come off the record as counsel, even though my understanding was that when the sentencing was done, I was done. I have assisted her from time to time since then because it's a client with some challenges, but I'm told I have to bring an application to be removed from the record tomorrow in person and arrive early to speak with Mrs. Sherwin prior to 12:30 p.m. in Hamilton. My Zoom setup and my file is in St. George's, so it would require me to be released by this court probably around 11 a.m. and I'm not sure I would be back before 2:30 p.m. at the earliest.
Not going to work.
Sorry?
I just said that's not going to work, is it?
No, it isn't going to work. I'm afraid this court must take precedence.
I had asked for a variation of the order, but I haven't received anything back. So,
Ms. Mulligan, I'm just received further information that the Supreme Court is prepared to push the time back to 12:30 because this court usually adjourns for lunch at 12.
but
It's not going to work from St. George's.
Yeah.
And I have sent an email to that effect to the court that I can't get there and get back after making the application.
No. And
Oh, I've just received an indication from, hang on, this just in. I am able, Mrs. Justice Simmons is able to let me appear by Zoom at 12:30 tomorrow. So that would work, and that's fine. And I'm sorry, it just came in. I didn't need to bother the court if I'd known that.
Well, it's going to work if it only takes half an hour.
I can't imagine it would take more. I can file whatever materials are necessary this evening electronically. So I can't imagine it would take more.
Okay. Well, I think from an abundance of caution, we will take steps to communicate with Justice Simmons that we need you at 1 o'clock your time.
Yes. Okay, and I will, yes, I appreciate that. I appreciate the assistance of the court, and I will do my very best to have the matter dealt with to assist the Supreme Court as well.
Thank you, and thank you for notifying us. 1 o'clock tomorrow, your time.
Sorry?
Thank you.
Right.
But we're adjourning till 9 o'clock tomorrow, Bermuda time.
I'm so sorry, I'm confused. Well, wait a minute. I've got confused myself. Of course, you're seeing Justice Simmons at 12:30.
Yes. Bermuda.
Right.
It's our 4:30.
Our 4:30. Yes. Okay. But we shall need you back at what will be 5 o'clock our time.
Yes. And I can advise the court of that.
Yeah, that'll work. That'll work. Sorry. The end of a long day in 2 different timescales. I will see you all at 9 o'clock Bermuda time tomorrow.
Thank you.
Thank you very much.